You may not have made any effort. The listener आपने किसी को नहीं. Yes, Mr. Panda.
2018 second application.
Lordship, RSC number 202/16. Respondent number 1 died 1 year back. The applicant has not taken any steps to substitute the respondent number 1.
So how are you affected?
I am for the respondent number 1.
Yes, d'accord. Supplementary list item number 1. Yes, Mr.
My lord, may I mention, my lord, item 49 of the list, weekly list. Monday's weekly list, my.
Monday to no Tuesday to.
Again, Tuesday.
Ito khuli rokhiyo na. Item 40.
49.
49, yes.
RSA 300/11.
2011, yes.
Again. Well, let's say LCR required thila LCR ta call for it and.
And I'm going to let it reach. Let it
Okay.
If the LCR is necessary, then we will. In
Yes,
many cases, LCR is not.
Can first appellate court has relied on every part in the LCR from the LCR, plain written statement and exhibits everything, my lord.
Remind the court below to transmit the LCR positively by 12th July 2024. List this matter in the week commencing 15 July. This order be communicated to the court below forthwith.
Great for me.
Number 1, my lord, may I please also. Petition is filing this petition for transfer of the criminal petition number 22/24 from the court of judge family court Khorda to judge family court Khorda. My lord, petitioner is pending order of the by the opposite party.
Subun again, mic recall.
My petition is apprehending attack of the opposite party in the court. That's why it's filing.
No.
Another thing is opposite party number 1 is also contesting a case before the Honorable Judge Family Court Puri. That's why the matter is transferred to the. My lord, can you see the I have lodged the FIR against the OP number 1 and others persons. They have attacked to the petitioner severely and admitted in the hospital. My lord, another thing, this case is also pending the JMFC Pipli for trial. She is also appearing before Pipli as well as in the Puri.
No ground. Sorry, the petitioner.
My lord, notice that she has
No.
my lord, kindly see the annex of 2, my lord, medical report. Severely attack page number 11 and 12 also.
Case will be decided.
से केस कर से गले सेठी मार पे बस मारी
बोले आपन मार देबे
थ्रेटनिंग सीता आसु जी पूरी भी गोटे केस कॉन्टेस्ट करियो से पूरी भी आस परियो.
The petitioner seeks transfer of CRLP case number 22 of 2024 from the court of Learned Judge Family Court Khorda to the court of Learned Judge Family Court Puri. So transfer is sought on the ground that the petitioner has been threatened by the opposite parties and their family members. Such regard, an FIR has also been lodged
Another ground
before the Delanga police station, which is registered under sections 341, 324, 326, 307, 506, 34 IPC. It is submitted that the petitioner apprehends that on his appearance before the court at Khorda, he may be subjected to attack again. It is further submitted that a divorce petition is pending between the parties at Puri, in which the opposite parties have entered appearance. All right, I'll issue notice. All right, issue notice. Type for letter. Issue notice to the opposite parties by speed post. Fixing a short returnable date, requisites be filed by tomorrow peremptorily. Place this matter on 31st July. I re adjournment. Yes, adjournment.
I don't know.
You pray for adjournment, it will be granted. That order will be passed.
মানে সে আইটা भी নোটিস
आइए,
আইটা भी নোটিস যাও
आइए review कर दो notice as above. है ना? In the meantime, if any application for adjournment is moved, সেটা আমরা লিখে
item number 2
Under the petitioner is the husband seeking transfer of criminal proceeding number 50/24 pending in the file of Judge Family Court Jagatsinghpur to the Court of Judge Family Court Barampur on the ground that the distance between Barampur and Jagatsinghpur is 260 kilometer and the petitioner is a police officer working as a police officer in Chhatrapur police station. So not only my lord, my submission is that not only to Barampur, any middle place, my lordship may only issue notice, I may agree.
No. You appear through virtual mode.
My lord,
You appear through virtual mode. কিছু দরকার নেই। কিছু দরকার নেই। The wife will be put to inconvenience unless that lady will be seriously prejudiced.
issue notice, my lord.
No. Why will I issue notice?
But the Kotak as well,
No.
260 kilometer, my lord.
Absolutely not.
But Chhatrapur is a, the ground I have taken, my lord. But Chhatrapur police station is a very sensitive police station, and he used to.
I know. I was the sessions judge there.
My lord.
I know how sensitive those police stations are, but that will not be a ground for transfer.
In my
No. The petitioner seeks transfer.
Only issue notice.
I will not.
Lordship, my lordship issue notice.
I will not issue notice. I will dismiss it. The petitioner seeks transfer of criminal proceeding number 53 of 2024
I prefer Kotak as well.
from the Court of Learned Judge Family Court Jagatsinghpur to the Court of Judge Family Court Barampur. Transfer is sought on the ground that the petitioner is a police officer presently posted in Chhatrapur police station. It is submitted that it would therefore be difficult on his part to attend the court on the date of posting of the case. Stop. After considering the submission and the ground, after considering the submissions, this court does not find the ground cited a valid ground for transfer. As the petitioner can always seek permission of the court to appear through virtual mode. In such view, moreover, it will cause inconvenience to the opposite party wife to travel from Jagatsinghpur to Barampur. In such view of the matter, I am not inclined to allow the prayer for transfer. The transfer application is therefore dismissed. It shall be open to the petitioner to seek permission of the court to appear through virtual mode. Further, the court below shall not insist upon personal attendance of the petitioner unless absolutely necessary.
item number 3
May please, my lord. The petitioner has filed this matter to transfer the divorce proceeding pending before the family judge Kendrapada to Cuttack, because the petition, the opposite party husband who has filed that divorce proceeding, he is residing at Cuttack. The place of service is at Cuttack. And this petitioner has filed 125 proceeding before this family judge Cuttack and is getting the maintenance. And the communication from the lady residing at Salepur. The communication from Salepur to Kendrapada is hazardous. From after getting down from the bus to reach the court and after finish the court work to come to Kendrapada bus stand is hazardous, because there is no communication. Bus बोलेगी ऑटो को क्या करेगा, ऑटो ये तो this is not rich lady. We have to wait for auto. When the auto will be fill up, then they will carry you to the court.
डेली করছতে বলি আপন ট্রান্সফার চাচ্ছেন না কোন
The party
কোন করে অটোওয়ালা উপর তো আমার কিছু কন্ট্রোল নাই
বুঝ পারলেনি।
অটোওয়ালা উপর আমার কি কন্ট্রোল লাগে? Auto wala deri koribe au kon koriya? Is that a ground for transfer, sir? You are at Kendrapada. And you are telling me that there is a communication problem between Kendrapada, Salepur and Kendrapada.
No, my lord. Lady is residing at Salepur.
ହଁ ହେଲା ସେଇ ସାଲେପୁର କେନ୍ଦ୍ରାପଡ଼ା ଯିବାଟା ଗୋଟେ
Communication from Salepur to Cuttack is easier.
ସାଲେପୁର କେନ୍ଦ୍ରାପଡ଼ା ନାହିଁ
ସାଢେ ଚାରିଟା ପରେ ବସ୍ ମିଳୁନି ଥ୍ରୁ ସାଲେପୁର
ନାଇଁ ଆପଣ 4:30 ପରେ କୋର୍ଟକୁ କାହିଁ ଯିବେ କି?
କୋର୍ଟ ପ୍ରୋସିଡିଂ ଡେରି ହେଇଯାଉଛି
No, no, no.
husband is also residing here.
No.
So place of work is at Cuttack and 115 people.
No, no, no,
He is also pending.
Sir, if there is a valid ground, yes, this court is willing to consider. In many cases, I have directed transfer of the cases. It is not as if I am not directing. But the court is not satisfied at all that there is a valid ground. Salepur Kendrapada is one of the busiest routes.
The matter is pending before the family court Cuttack. The proceeding is pending, 115 proceeding is pending before.
So why is he going to Kendrapada then?
The husband has filed that proceeding before Kendrapada. But husband is residing at Cuttack.
That is his problem. If he is residing at Cuttack and he has filed a case at Kendrapada, it is for him to decide that. He will travel. It is his problem. He is not
I am the opposite party there. I have to travel there.
Oh, so you have to travel from Salepur to Kendrapada. He is traveling from Kendrapada to from Cuttack to Kendrapada. No, I don't find this a valid ground. Sorry. The petitioner seeks transfer of CP number 2921 of 2019.
Well, let me pray one thing. The notice may be issued.
No, pending before the family judge Kendrapada to the court of Judge Family Court Cuttack. Therefore, transfer has been made on the ground that there is a lack of communication between Salepur, where she is residing, and Kendrapada. As such, the petitioner is facing difficulty in attending the court on each date of posting of the case. That apart, her husband is residing at Cuttack. After considering these submissions, this court does not find the grounds cited to be valid for transfer. Stop. The transfer application is therefore dismissed. It shall be open to the petitioner to seek permission of the court to appear through virtual mode, if so advised. Next. Further, the court below shall not insist upon her personal attendance unless absolutely necessary. That's all. Yes.
Item number 4.
Yes.
Wife's application for transfer from Barampur to Raulkela. Wife has been deserted since 2022. File an application under section 125 at Raulkela. And my husband is also appearing in the at Raulkela because my
Issue
husband
notice.
is residing at.
All right, issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by tomorrow peremptorily. List this matter on
31st July.
31st July. Yes. Adjournment.
Lordship pass that. Unless my lord order is there.
Hey, there will be an order, sir. Adjournment there will be an order.
बुझी पारलिन से.
See, बुझिया दरकार हो.
Item number 5.
May I please your lordship, my lord, the petitioner is the wife having a baby on her lap. Lord, she has been
Which matter are you referring? Item?
5, my lord, 5.
Item 5. I'm sorry. भूल matter टा खोल दिले. Item 5.
The transfer of matrimonial suit filed by the
Just-
husband, my lord. Divorce proceed.
Subhasri Samal.
My lord,
Is the petitioner's name Subhasri Samal?
yes, yes. But she is having a baby, my lord, on her lap. And
You want it to be transferred from Talcher to Angul.
not altered.
Why?
Why, my lord, she is a minor child.
Hmm.
And my lord, she has no other member to look after the baby if in the case he attends the proceeding, my lord. And my lord,
Well, not even 20 kilometers.
that I don't, my lord, I understand.
Not even 20 kilometers.
But the area is something under the behavioral part of the husband. Behavioral, my lord, behavioral part is the husband and economic. My lord, I must not venture to house your lordship, my lord, what are these are the three conditions. The, my lord, she is working in a MCL. My husband is working in MCL, my lord, and so there will be no problem on his part to move to the Talcher, Hon'Ble, my lord. And economical status, behavioral, my lord, she is having a PC drinking, my lord, drunken person. All these things cumulatively may be considered by your lordship.
Yeah, what is the ground?
Down, my lord, she is a minor child. With the appellant is having a minor child of 3 years, my lord. And the economic condition, because she is unemployed and depending on her parent is an old person, my lord, very miserable condition. And therefore, my lord, on the other hand, the husband is serving in MCL and his monthly income is 70,000, 75,000 more. My lord.
All right, issue notice
Hon'Ble.
to the opposite party by speed post. Adjournment. There will be an
It's
adjournment.
on application being made. Oblige, deep oblige.
Yes.
Item number 6.
Well, in this case, my lord, I was directed to take the instruction, my lord. May I pray, my lord, this matter will be taken up only on Friday.
Had earlier filed its application which was disposed of granting leave to zone. What was the status of the representation submitted by him?
On Friday, my lord. I pray for only Friday.
He's appearing in person.
But that is what my lord.
Travel to the court.
Sorry,
time and again.
I
Had it been a lawyer, I would have.
Yes.
I would not have raised this issue.
only one day.
But Friday there will be no further adjournment.
No, your lordship mentioned that.
All right, we'll take it up Friday. Sri Asan Patnaik, learned AGA, requests for a short adjournment as he has not received the instructions as yet and expects to receive the same by tomorrow. Place this matter on 5th July.
Yes.
It is made clear that no further adjournment shall be granted.
Item number 7.
May I please receives?
Yes.
Petitioner. My learned friend will also have to produce those documents.
Yes. I remember.
May I be permitted to mention? Well, in this case, my lord, in fact, there was previously one appeal. And entertaining that appeal, the order was passed in the year 1995. Since there was a submission by the my lord, senior my lord, on the other day, that during the first appeal, some documents were submitted before the appellate authority. That is why
Two sets of document. One is that his name was included in the recognition renewal form, and second, he was deputed to examination duty. Isn't it so, Mr. CORAM? Yes.
So my
These two documents I had asked Mr. Patnaik to produce.
yes, so also to me to produce that file of 1995. Though my lord, we took all sincere effort, my lord, we could not. But what I found, my lord, in the year this second appeal, my lord, that original file is with me, and most of the documents which were relied upon by the petitioner and the opposite parties management committee and in the previous appeal, in the written note of submission and other documents, my lord, they have submitted those documents.
They are available.
That is available with me, my lord.
What about
So
Mr. Patnaik?
My lords, exactly, I do not know how to express my difficulties. And as I have got a bitter experience, the principal of the college have retired and a new principal has joined. And he has joined whenever I telephoned him and I wanted to communicate to my lord's direction. He said, all those documents are not in existence. But you have to, I told him, whatever you say, you have to file an affidavit. I cannot say simple way because my lords are directed and no further time shall be granted.
No, I don't intend to keep it pending any further.
Yes.
I will record your submission, Mr. Patnaik.
Yes.
And the documents that Mr. Patnaik has produced or intends to produce, I don't know what are those documents. There are two things I'll pass it over. In the meantime, I think you can pass it over to
Yes, ma'am.
both Mr. Kora as well as Mr. Patnaik. They can let them see
Yes, ma'am.
whether they are the same documents which I had called for, which I wanted to see.
Yes.
Yes.
But I have also brought some original records which I will also produce.
Yes, yes, ମୁଁ pass over କରିଦଉଛି
Yes.
ଆପଣ ଟିକେ ଦେଖିଦିଅନ୍ତୁ.
Yes, yes.
You go through that file.
Yes.
If it meets your requirement and end of the matter, we'll close it. But today we are going to close it.
Yes, yes.
Whatever documents are there, you'll also make.
Whatever is there.
Yes.
Whatever then ଆପଣଙ୍କ ସେଟା
And
ସବୁ.
let me also take note of my learned friends.
I will at the time of passing the final order, I will. So pass over.
Item number 8.
Mr. Patnaik, kindly go through. Please go through. I am passing it over. I'll take up other matters, you should again. Yes. Item 8. ଛାଡି ଦିଅନ୍ତୁ ତାଙ୍କୁ ଟିକେ ଛାଡି ଦିଅନ୍ତୁ. Mr. Koro, kindly just go through those documents and please. Yes, item 8. What was the last order? Point of dispute in this case appears to be whether the petitioner had submitted the application within the due date, that is 15/2010. There are documents showing contradictory views of the same. Land State Council is requested to peruse the original file and appraise. Yes.
I have produced, I have the original file with me, madam. With respect to the collection of the documents,
This is the case of Anganwadi.
Yes, sir.
Yes.
with respect to the
So,
collection,
say you did it.
Yes, yes. Second.
I remember.
but there was an advertisement wherein the due date of submission of all the application was 15/1/2010. But in the meantime, before that date, a letter was issued by the CDPO to submit a document by 30th. So that created all the confusion, madam. So ultimately, madam, that was with you. The only point is to be decided, madam. As on the due date, that is on 15/1/2010, how many number of applicants were there? It is only the Swarnaprabha Tripathi, or there were 8 number of candidates, including Pushpanjali Malik. Now, my lord, what the original document has been provided to me, I found that it consists of 8 number of candidates.
On that day, on 15.
Yes, because the date of receipt of such documents, my lord, including the document of Pushpanjali Malik, that says, my lord, it is on 10/1, 11/1.
Yeah, within 15 or
Within 15. So, my lord, now the view expressed by the ADM, my lord, while disposing the appeal, my lord, what I found, my lord, from the different documents, my lord, there are 8 number of candidates as it has been recorded, and the documents which are collected in original, my lord, that is also provided to me, my lord, which are actually that is in the Xerox form, my lord, but that has been provided to me. It consists of all, application form of all the 8 candidates. Then the second one, my lord, this is the register. The register says, my lord, that with respect to GP Mohura, name of Anganwadi Center Alikia, there are 8 number of candidates, my lord. It is an original document signed by the CDPO, my lord. And the name of Swarnaprabha Tripathi, the opposite party, my lord, in this case, that is at serial number 3, and name of the present petitioner, my lord, is at serial number 4. This is another.
So this becomes a perverse finding then? The finding becomes perverse?
I will come
Yes,
to that one.
yes.
My lord. Then, my lord, another register has been produced before me. It is the resolution register, my lord. That resolution register, my lord, number 17, Gram Panchayat Mohura, Kendra Alikia Dubepur. ସେଥିରେ ମଧ୍ୟ ଲେଖା ହେଇଛି ପଢେଇ ଦଉ ଏହି କେନ୍ଦ୍ର ପାଇଁ 8 ଜଣ ପ୍ରାର୍ଥିନୀ ଆବେଦନ କରିଥିଲେ 8 ଜଣ ଯଦି ହଉଛି ଆଉ ମାନେ ଅନ୍ୟ ଗୁଡାକ ପଢିବା ଦରକାର ନାହିଁ 8 ଜଣ ଯଦି ହଉଛନ୍ତି ତାହେଲେ it includes Pushpanjali.
Yes. So then
my lord, Anganwadi appeal, the order of appellate authority, my lord, that is on challenge before this honorable court, my lord. There, my lord, what I found, my lord, that there is a written note of submission and submission of records by the opposite party, Swarnaprabha Tripathi. In that enclosure, my lord, there is a enclosure with 7 number of candidates. That is what we have actually relied upon, and to justify the stand of the ADM, my lord, as the appellate authority, we have filed a counter on by the CDPO, my lord, because the ADM is not a party in this case. So CDPO, my lord, she filed a counter referring to these documents, and because that was not clearly legible, my lord, a type copy is also available in our counter. Here, my lord, if your lordship will come to one document that is, there are several documents which have been taken into consideration. And ultimately, my lord, there is a list of documents filed by the applicant. So no proprietary party was the appellant, my lord, there. On 19/12/2011. So there are a series of documents, my lord. One of the document is that that list consists of 7 number of persons, excluding the name of the.
So let us come to the order of the ADM.
Yes,
How has he dealt with this?
yes.
I think we can gone through the written note. This is written note of argument. The first thing that we need to consider is, irrespective of what written note of argument she has filed, the original documents, they reveal a different story, and they are to be considered. So that he should have taken pain to consider the original documents and then pass order, and to see whether the appellant had made out a case or not.
Correct.
So it has to be remanded.
Remand.
It has to be remanded.
I
It has to be remanded for fresh consideration. Yes, Mr. Mathi.
No, so that is, if any objection required by the open number 1 lordship, that is a date was fixed for objection. And that in that particular date, the open number 1 has not filed any objection regarding any of the.
It doesn't matter. Still, that does not stop her from filing an appeal.
No, that's the guideline of the organized worker guideline is there.
Yes, I am talking of that guideline itself.
Yes.
Guideline में जो procedure लिखा है जी, से procedure है. Yes, there is a stage where which there is a stage for filing of objection.
Yes, yes.
There is also appeal is also provided.
Yes.
That provision does not say that unless you file an objection, you cannot file an appeal.
No, that is, if there is a.
So he has filed an appeal.
Yes.
I think this is the best order you can get. Remand. It has to be considered. The ADM has to consider taking into account
So,
the original document.
that is a wrong interpretation by the ADM lordship.
Sir, you are taking a risk. You are arguing a matter. You are taking a risk.
No, lordship.
I leave it to you.
No, lordship. Because the.
Simple remand କରିଦେବା ଆଜ୍ଞା ସେ ଆଉ ଥରେ consider କରନ୍ତୁ ଏଇ document ଗୁଡାକୁ I'll refer to these documents.
Yes, lordship.
I'll refer to these documents in my order
Yes.
and I'll remand it so that he can consider it.
Yes, lordship. Yes, lordship.
This court obviously cannot make a ruling inquiry.
Yes, lordship.
Is it? ସେ document ଟା produce କରେ.
But also taken into consideration the unnecessary 1/C and 1/D.
Whatever documents, it will be open to you to also produce documents, but I don't think you can get over these documents. These are original documents.
But they have not.
If she has applied in time within that 15 it is how can you ignore her application?
No, the last date was scrutiny was 16/1, my lord. Then why it is extended to 31/2, my lord?
That's a different matter. We are not on that.
Only
Our application has been rejected on the ground. देखो
she has not applied, my lord.
that she has not applied. But if the court finds if there is a material to show, prima facie material to show that she has applied, how can you say that? Anyway,
That is unnecessary 1/C and two same date. Two same.
her learned counsel for the petitioner. No, I am disposing of yes, Mr. Patnaik.
Yes, ma'am.
What is your submission?
Well, my submission, my lord, the views taken by the ADM as the affiliate authority in this case, my lord, that taking into consideration some of the facts and some of the documents relied upon by the contesting parties.
But the original file he has not produced.
No comment has been made, my lord.
Obviously, he has not said so. He has not said that he has seen
Yes.
the original file.
Yes.
If he doesn't say, how can we presume that he has seen it?
Yes,
We can't. So we have to rather, the order shows that he has not seen.
yes.
So let him consider it.
I-
The petitioner has approached this court with the following prayer. The facts, briefly stated are that an advertisement was issued by the CDPO Satyavadi on 18/1/2010.
No.
No, 30/12/2009
9.
for engagement of Anganwadi workers or worker of who center Alikya
bracket
Dubaipur Anganwadi Center. The last date of submission of applications was mentioned as 15/1/2010
date was scrutiny.
and the date of scrutiny was 16/1/2010. it is the petitioner's case that she submitted her application. କୋଉଦିନ
15/1/2010
ଦେଲେ କୋଉଦିନ 15 ସେ ବି ଆପଣ ଜାଣିନାହାନ୍ତି
received the application.
ଆପଣ ଦେଲେ କୋଉଦିନ
My application ଆଗୁଆ ମୁଁ ଦେଇଛି but my application received on 15/1/2010. That is the
petitioner
application.
petitioner କଣ ଲେଖେ petitioner's case is that she submitted her application before the last date.
ବିପନା ସେ ସ୍ପେସିଆଲି 15 ସେ କହୁଛନ୍ତି
No, no, no. My application received on 15/1/2010.
ସେ କହୁଛନ୍ତି
ଆଜ୍ଞା ମତେ ଟିକେ ଡାକିବାକୁ ଦିଅନ୍ତୁ ଏଡିଏମ ଙ୍କ ପାଖରେ ଯାଇକି ବାଡିଆ ବାଡି ହେବେ before the last date. It so happened that another notice was published by the CDPO.
another letter was issued on 18
By the CDPO on 18/1/2010, stating, fixing the last date of receipt of applications
30
as 31/2010. সেটা withdraw ହେଲା ନା, that was withdrawn.
ନାଇଁ ଜାଣା ସେ ମଡିଫାଇ କଲେ ଯେ କାଲି ଆମେ ଭୁଲରେ ଆପ୍ଲାଏ କରି
Subsequently, a clarification was issued that the subsequent that the letter so issued letter was wrongly issued. In the selection process, the petitioner was found suitable, and accordingly, her name was recommended for engagement as Anganwadi.
may submit during pendency of the application the petitioner approved this honorable court. This honorable court directed the sub collector to consider the matter, they were taking into consider the application submitted on 15/1/2010.
ମୁଁ ଭାବିଲି ମୁଁ ଦେଖିଲି ସେଟା ମୋ ସାମ୍ନାରେ ଅଛି ଯେ ମୁଁ ଭାବିଲି ହବ ଆଚ୍ଛା ହଉ ଯଦି ଲେଖିବ କହୁଛନ୍ତି ଲେଖିଦେବ
unnecessary 1/E site doctor.
wait କାଟନ୍ତୁ ହେଲା ହେଲା second notice was such notice was challenged. You had challenged it
Yes.
by the present opposite party number
One.
number 1 before this court in WPC number 2140 of 2010. By order dated 22/2/2010, this court granted liberty to the petitioner, that at present opposite party number 1, to file appeal before the sub-collector Puri. Accordingly, the sub-collector Puri, by order dated 30/10/2010, took note of the submission made by the CDPO that no fresh application was received in respect of the advertisement made on 18/1/2010, and that selection shall be made on the basis of the original advertisement dated 30/12/2009, in which the last date of receipt of applications is mentioned as 15/1/2010. The sub-collector therefore disposed of the appeal by directing that the case of the opposite party, case of the present opposite party number 1, shall be considered at the time of selection. In the selection process, however, the present petitioner was found suitable and her name was recommended for engagement as an Anganwadi worker. Did you join?
Yes, sir.
Huh?
till she continued.
After the order of the ADM, the petition, she was disengaged and petitioner appointed. After the order of this honorable court in this writ application, the petition again removed. My lord.
No, my lord, petitioner till continue her post till date.
Shut up, Sitra, we will not get into that. Challenging such selection of the petitioner, the present opposite party number 1 filed Anganwadi appeal, filed appeal being Anganwadi appeal case number 6 of 2011 in the court before the additional district judge, additional district magistrate Puri. Stop. After hearing the parties and on going through the records, the ADM held that the petitioner had not applied pursuant to the had not applied within the last date of receipt of application as per the advertisement issued on 30/12/2009, and accordingly held her selection as illegal. The selection was set aside.
And thereafter,
Please don't disturb me, sir.
yes, ma'am.
I know what you are saying, but I don't find it relevant at all. And since I'm remanding it,
Yes.
if that would have been relevant if I would have passed a judgment on my own. But I'm just remanding it. Why should I go on to those facts?
Yes, ma'am.
It's a basic fact. I'm looking at. Last time. Election was held illegal, held to be illegal. Stop. The selection was thus set aside and the appeal was allowed. Being aggrieved, the petitioner has approached this court with the prayer as mentioned above. In the counter, counter filed by the CDPO, the stand has been taken that the petitioner had not applied before 15/1/2010. Whereas the opposite party number 1 had applied. Come to page running page 50, running page 6 of your counter.
Yes.
Whereas had applied within the due date. Stop. In short, the on such basis, the impugned order was sought to be justified.
Yes.
Counter affidavit has also been filed by opposite party number 1, stating that she had applied within the due date, but the petitioner had not. The petitioner's application was received pursuant to the subsequent notice dated 18/1/2010, which was subsequently held to have been wrongly issued. Heard Sri R.N. Mahanti, learned counsel for the petitioner, Sri S.N. Patnaik, learned AGA for the state, and Sri
MR Panda.
MR?
Panda.
You are not MR Panda?
No.
Then?
I am on behalf of Mr. Panda. He is
ଆପଣଙ୍କ ନାଁ କହୁନାହାନ୍ତି କି?
KC Rajguru Mahapatra.
ମୁଁ କାହିଁକି ତାଙ୍କ ନାଁ ଲେଖିବି? ଆପଣ ଛିଡା ହେଇଛନ୍ତି?
He has given minutes of appearance memo for me, but I have not filed.
I was a young lawyer. I was arguing before Justice P.K. Mishra in the Road Court number 6. And that's a reported decision also. There's the doctrine of added peril. It was an insurance appeal. I was arguing the matter. when he dictated the judgment, he asked me, Justice Mishra asked me, your name, what is your good name, young man? No, look, I said the name of my senior. People are ମାନେ ଗୋଟେ ୱାର୍ଡ ଫେଲେ ମୁଁ କଣ ଗଞ୍ଜେଇ ଖାଇ ପଚାରୁଛୁ ଆପଣଙ୍କୁ ଆପଣଙ୍କ ନାଁଟା କଣ କହୁନାହାନ୍ତି ୟଙ୍ଗ ଲୟର ତେଣୁ ଡର ଲାଗୁଥିଲା ସେଠୁ ମୁଁ କହିଲି ମୋ ନାଁଟା and you see the greatness of that judge. He not only wrote my name, ମୁଁ କାହିଁ କହୁନଥିଲି because I am not a panel advocate of insurance company. The insurance company may take a view that my senior is not appearing despite being the but he not only wrote my name, that was a reported judgment. CLT re reporting through upon. So whoever appears, sir, we,
Also, I have previously status quo maintain the disposal of the ADM nursery.
no. Oh, ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି KC Rajguru Mahapaତ୍ର.
KC Rajguru Mahapaତ୍ର.
I heard say KC Rajguru Mahapaତ୍ର, Land Council for the private opposite party number 1. The facts of the case as narrated are not do not appear are not disputed. As it appears, after issuance of the advertisement on 30/12/2009, fixing the last date of receipt of applications to as 15/1/2010, the CDPO Satyavadi issued another notice on 18/1/2010, extending the last date of receipt of applications to 30/1/2010. On the next date, that is on 19/1/2010, another notice was issued stating that the notice issued on the previous date, that is 18/1/2010, was incorrect, and that no applications shall be received on the strength of the notice dated 18/1/2010. This the issuance of the second notice appears to have led to considerable confusion. Certain documents were produced before the ADM during hearing of the appeal, on the basis of which it was held that only 7 persons had applied before the due date, that is 15/1/2010. This court, however, the State Council, however, this court has perused the original file and the registers maintained in the office of the CDPO Satyavadi relating to selection of Anganwadi worker in pursuance of the advertisement dated 30/12/2009. These records have been produced in the court by Sri S.N. Patnaik, Learned State Council. देखिए, आगो फाइल टा दियो, आगो फाइल टा दियो, को फाइल टा
से दीटा फाइल रो गोटे होची अपील फाइल आ गोटे होची एप्लीकेशन रिसीट फाइल जोथरे एप्लीकेशन गुडा को 1 ରୁ 8 लेखा कि अछि सेटा होची एप्लीकेशन रिसीट फाइल ना गुडा प्रथम
from the documents available in the original files, this court finds that the names of 8 applicants, including the petitioner and opposite party number 1, have been mentioned. There are also documents to show that all these applications were received prior to 15/1/2010. Okay?
Yes. It has an appeal right.
The, देखिए,
See register.
perusal of the
Have register.
এটা ଗୋଟେ ରେଜିଷ୍ଟର ଯୋଉଥିରେ ଗୋଟେ ଲିଷ୍ଟ ଥିଲା ଏଇଟା perusal of the register maintained by the CDPO also shows receipt of 8 applications including the ones including that of the petitioner and opposite party number 1 before 15/1/2010 এটা ଗୋଟେ ଇଏ ଅଛି ମହୁରା ଗ୍ରାମ ପଞ୍ଚାୟତର ଅଳିକିଆ 8 ଜଣ এটা ରେଜଲ୍ୟୁସନ ଟା
এটা হচ্ছে resolution.
the original resolution passed on 7/9/2010 also shows that 8 applications were received. No. Thus, there is prima facie evidence of receipt of 8 applications before the due date, that is 15/1/2010. Such being the case, the finding of the ADM becomes vulnerable. It is apparent, it is evident that while hearing the appeal, the ADM has presumably not gone through the original file maintained by the CDPO, Satyavadi regarding receipt of containing the details of receipt of applications by the candidates, as also the original registers showing the same stuff. Since the this court is of the view that this court is of the view that these are vital pieces of evidence that can have a material bearing on the final outcome of the appeal. Of course, this court would hasten to add that it has not expressed any opinion either way on merits of the case. It would be proper for the ADM, being the appellate authority, to take into consideration the original documents available in the file before taking a final decision in the matter. For the foregoing reasons, therefore, the writ application is allowed. The impugned order passed by the ADM is set aside. The matter is remitted to the ADM for hearing of the appeal afresh after considering the original afresh. Stop. While hearing the appeal, the ADM shall call for the original file and the registers and such other documents / records that he may deem necessary for the purpose of deciding the case. It shall also be open to the parties to adduce evidence in their in support of their cases. The ADM shall grant necessary opportunity to all concerned and pass a reasoned order within 2 months.
2 months from the date of receiving the.
within 2 months from the date of production of certified copy of this order by any of the parties. Till such time, status quo with regard to the engagement of Anganwadi worker of Alikia so and so Anganwadi center shall be maintained.
Item number 9, can I take back those files, man?
Take back the files. OJC 2789. 2789 कौन हुई थी?
That court has not entertained. However, given liberty, if she is otherwise eligible, he will be allowed to participate in the advertisement and his case will be considered with others.
नहीं सी order था कहीं?
They till last time,
भेज दिया था?
yes, yes, last time I have told.
नहीं थी भाई इसको थी कुछ
I have produced in the court. Your may kindly see.
नहीं.
So till regular application, that post could not be filled up with in that connecting matter. The person concerned is prior to that vacancy of that post, he is continuing there.
Is there any
That order?
no, is there any prohibitory order?
No such.
But that is the reason when this pendency of this connected writ application, they have not proceeded, and that is the stand we have taken in our counter affidavit. Because of that pendency of that application, that regularized appointment has not been made, and subsequently when he is continue on stopgap post matter, another advertisement was made for that fill up of that post matter. And that at that juncture time, this present declaration has been filed, and by interim order, he has allowed to continue, and till then he is continuing.
Right.
Only for 1990 to 2001, you will also may kindly see annexure A by 2 at page 19 of my counter.
A by 2.
Yes, madam.
Yes.
A by 1, madam. Sorry, A by 1 at page 18.
Yes.
Last one para. Please note that this is the last and final extension of a contract. Appointment after this, no contract appointment order will be issued. After this one, when advertisement is made, he challenged that, and this Hon'Ble Court director till continuance till that regular post has been made.
So why did you take steps for regular appointment? There is no bar.
Because
I've seen the earlier order, earlier writ application. There is no such order prohibiting you from
that is the reason, because in this case, my lord, what happened? This matter, the order your lordship is just looking at. Subsequently, a miscase has been filed for violation of court's order. That I just want that order that my lord, the miscase has been filed that he is not allowed to continue, and by virtue of the personal appearance for us to be made in that case. That is the reason. Subsequently, in the pendency application, that has not been done. But I got instruction from them. No, there is no legal bar to continue that.
Hey, they heard that way, they could have obtained leave.
That has not been done.
Lord, there are some it was left to outsourcing. Then I filed an application that they are going to fill up it by outsourcing. This Hon'Ble Court directed that he shall continue. For that post, no outsourcing was directed. And he has been continuing, your lordship may kindly see, from 1999. Now 25 years.
Let us go to your initial appointment. You have that.
Contractual appointment, my lord, I have annexed, your lordship may see annexure 1 at page 9.
Initially, otherwise he is not eligible, and he is barred by that overage, madam.
And I have said that.
Overage at the time of
Yes, ma'am.
initial engagement.
Yes, ma'am. And that is that prayer in the writ application of that 2001 also to relax his age and allow him to participate in the proceeding, in the advertisement.
Yeah, that was for the process of regular recruitment.
Yes,
But
yes.
for the process of regularization, which they have done it for several other employees, that also my averment is there. They did it. But for the petitioner, they didn't extend that benefit, even if the job is of perennial nature. He is a stenocom typist working from 1999 for 25 years. And if some other persons could be regularized, my lord then wanted to know that why they have not made the regular recruitment in the process. Even if
What is this page 12 of the writ application?
my lord,
A requisition has been given to the district employment officer.
that
Page 12.
yes, my lord. At annex page 12. Page 12 is the requisition, my lord. Where they say that these posts are vacant and they wanted the.
So who all have been regularized? Where is that document?
There is no regulation, my lord. In that vacation, that advertisement, the person who has appeared in the exam, and they have given appointment. And they are previously they are continuing in the contractual. They are considered along with others, and they are not regularized. Given the appointment press appointment.
No. They were
Given the appointment.
I let me kindly see the rejoinder affidavit which I have filed. The rejoinder affidavit in paragraph 4.
Yes.
That the petitioner humbly submits that services of similarly situated employees have been regularized since long. It may be submitted that one Reena Sahu, who was engaged on contractual basis, was ultimately observed in the regular establishment from 5/7/2001, and furthermore, one Mr. Amareshwar Mishra, who was engaged from 15 to 89 to 30th June 2000, with breaks in between different spells of appointment, was also appointed as lower division clerk on regular basis, with effect from 1/7/2000. The services from 15 to 89 was also directed to be taken into account for the purpose of determination of his qualifying services for pension. Similarly, one Mr. Kishore Chandra Samantray and another Mr. Pramod Kumar Dalai, who served as driver and group D employees respectively from 1/12/86 to 30th June 2000, with breaks in between their spells of appointment, were appointed on regular basis. As such, their continuance from the date of initial joining on contractual basis were also directed to be taken into account for computing the period of qualifying service for pension. The discrimination meted out to the petitioner in the matter of regularization in service marks of malafide and is a violation of Article 14 and 16. I have named all these persons who were regularized, not by process of any regular recruitment process. They worked as a contractual employees with 90 days.
You respond to this, Mr. Maharana, by way of an affidavit.
Yes,
I and bring it on record. I will also say whatever process you have adopted to fill the posts, regular posts, that you have to show to the court.
And factory inspector and the date of his joining, he is not eligible to be hold that post.
So why did you allow him to join?
But only for that. That is the reason. Your also may kindly realize.
You stop him to be there.
In 2001 itself, my lord, we have given specifically your service should cannot be continued. It is the last. And subsequently, it is by virtue of
2001 for which Yes, ma'am. That is because of the interim order.
2001, my lord.
So in 1999,
Yes,
when you appointed him, even the contractual basis, If according to you, he was not eligible, he was overaged, when to appoint him?
Exactly, my lord, that.
So that
That we have.
so the principle of estoppel will apply. Though not strictly, because there can't be estoppel against law, still, by your own conduct.
That only, my lord, he limited period his work, my lord, but 99 to 2001.
Employee Anyway,
That is also, you also know that continuance by virtue of orders.
That is, Uma Devi and all those things are there, but anyway, heard further arguments. In course of hearing, Sri S.K. Das, learned counsel appearing for the petitioner, draws attention of the court to the amendments made in paragraph 4 of the rejoinder affidavit filed by him, wherein names of certain employees similarly situated as the petitioner have been mentioned, who have in the meantime been regularized. Stop. This court would like to know the response of the opposite party institute in this regard. Let an affidavit along with the relevant documents be filed answering the amendments of the rejoinder as mentioned above. List this matter
31st July.
on 31st July.
Right.
Affidavit will be filed in the meantime after serving copy on the other side.
Interim order to
Continue.
Item number 10.
Last occasion, my own friend for the petitioner has filed a petition for amendment, which I last occasion requested for some time to file the objection. As yet, the objection is not ready, my lord. I have also informed him that for some other date. In the meantime, I will file the objection to the amendment. Because
Mr. Panda, this is a 2014 matter.
my lord, up to 2014, the writ petition is. He retired in 2020, 4 years.
All right, I'll grant you.
After 4 years of retirement, he has come with an amendment, seeking amendment which changes the entire nature and.
So you file your
To
objection.
that extent, if I am given opportunity to file the objection, my lord has to decide whether the amendment is allowable or.
Whether it can be allowed or not, I'm not saying I'm not allowing the amendment. But you should file your all right.
Because otherwise, what happens? The entire prayer has become infructuous. Because now, in the meantime, he has retired. He has filed the matter in the year 1914. He retired in 2020. Now, in 2024, he is seeking for an amendment to change the prayer, though it changes the entire nature and character of the.
We'll see that. We'll see. Sri Panda Learned Counsel for the opposite party requests for further time to file objection to the IA. Place this matter next week. Objection, if any, be filed in the meantime. Next week it will come. When next Wednesday.
Let it come on 18 or 30.
All right. 18 July.
I don't know, 11.
It is made clear that no further time shall be granted for the above purpose.
May I please? Last order, Lordship. The counsel for the opposite party number 6 Sarpanch has taken time to take instruction from the new Sarpanch my lord.
My lord, actually new Sarpanch is not with my contact, my lord. I have contacted the earlier Sarpanch who has given, he has died. She has died and his husband has informed me that in new.
Sarpanch ko etre kichhi achi?
Sarpanch ko instruction heitala. Disengage kariya pai.
I am nothing to.
Jota mu challenge.
So you have to take notice then.
Yes, ma'am. Then
You have to take
notice
notice.
will be
Can I pray limited prayer? Let actually there are two show cause. One show cause notice with twofold allegation. Accordingly, I have submitted my show cause. Thereafter, the video made other several represent allegations and requested the collector to take step. Accordingly, it was directed to disengage me to the Sarpanch my lord. Though yet no disengagement order has been issued, but I have not been allowed to work. So the annexure,
What order can be passed now?
Lordship
They
may
will
send it
suppose-
to the collector, let him find out as to what has happened and arrive at a conclusion.
Yes, sorry.
In fact, serious allegations were made against him, for which he has been.
Annexure 3, page 12.
This is the first show cause?
It's the first show cause.
This is the first.
First show cause. This show cause is ଗୋଟେ allegation misbehaved the teachers. Second one is misappropriation of 2,90,000.
Gala. Then
I have replied and accordingly also I deposited 2,90,000.
again there was another.
Again, no show cause notice. Again, annexure 7 your lordship may see the video has written giving another allegations like issuance of the card to my relatives, misdistribution of PDS, etc., etc.
So this is a fresh show cause.
Fresh show cause. No, on that allegation, I have to make a fresh show cause, but no show cause has been issued. And on that letter, your lordship annexed to it, the from the office of the collector has given that you take immediate step.
Without giving any further show cause.
Any further show cause. And the BDO has directed the Sarpanch to take action against me. The stay order has been
The
given.
petitioner was engaged as Jogan
Yes.
under one of Babebir
Babebir Gram Panchayat.
Gram Panchayat in the district of Nuapara. While working as such, the show cause notice was issued.
Annexure 3.
What is annexure 2?
Annexure 2 is the notice by BDO. Basing upon that, collector has show cause notice.
He was called upon. While working as such, a show cause notice was issued by the collector on 16/12/2021 to the petitioner, asking the petitioner to show cause as to why he shall not be disengaged for allegedly misbehaving people as well as teachers during preparation of smart health card, and further misappropriating government money amounting to rupees 290,882. Pursuant to such notice, the petitioner in his reply submitted a reply on 23/12/2021 explaining citing all relevant facts, as also the fact that he has already deposited the allegedly misappropriated amount. Who deposited? Government treasury
PDF account, right?
in the PDS account.
But ये भी BDO जणैछन्ति collector को annexure 6 page 16.
Such fact was also informed by the BDO to the collector in his letter dated 5/1/2022. While the matter stood thus, the BDO Boden in his letter dated 24/2022 addressed to the collector referred to certain illegalities allegedly committed by the petitioner and suggested that necessary steps be taken for his disengagement. Upon receipt of such letter, the collector, by letter dated 30/4/2022, accepting the suggestion of the BDO. कैसे टेक करागला सी लेटर टा
Annexure 8 page 18.
directed the BDO to disengage the petitioner. Annex 9 টা কোন কোড অফিসার রিলিজ সেম তো?
That is the impugned order.
କୋଡିଏ ଚାରି 2022 ହଉଛି ବିଡିଓ ଲେଟର କଲେକ୍ଟର।
Pursuant to such order, the BDO
To the collector.
by letter dated 22/6/2022 directed the Sarpanch to take immediate steps for disengagement
Thereafter.
of the petitioner as Joganshu Sahayak by holding a special GP. At a resolution actually GP meeting over that. This court finds that paracurriculum. This court finds that action for disengagement of the petitioner has been taken without issuing show cause or calling upon him to explain the so-called irregularities and illegalities allegedly committed by him. Stop. Since it is a question of livelihood of a person, it is imperative for the authorities to adhere to the principles of natural justice as enshrined under Article 21 of the Constitution of India before taking the drastic step of disengaging the petitioner from service. Stop. This court therefore holds that the action of the authorities as narrated above cannot be countenanced in law. Stop. The writ application is therefore allowed. The impugned order under Annex
9
ନାଇଁ ସେଟା ସବୁ ହବ ନା ଗୋଟା ହବ କି?
Next 9 ଟା
କଲେକ୍ଟରଙ୍କ ପାଖକୁ କଲେକ୍ଟରଙ୍କ ଅର୍ଡରଟାକୁ ସେଟା ସେଟ୍ କରିବାକୁ ପଡିବ ନା? Where is that collector's order? Page ଏଟା ନା କେତେ ନା? 914 କଲେକ୍ଟରଙ୍କ ଅର୍ଡରଟା କାଇଁ ମୁଁ?
914 has been filed.
କଲେକ୍ଟରଙ୍କ ଅର୍ଡର ତ ନାହିଁ ସେଟା ସିଭିଲ ସପ୍ଲାଇଜ ଅଫିସର
My
କରିବ।
lord.
The impugned order
Annex 8
and the impugned orders under Annexure 7, 8 and 9 are hereby set aside. It should be the BDO actually. What do you say? Now will direct the collector.
collector kind of video
Collector hearing the parties, let him take a final.
All right. The matter is remitted to the collector Nuapada, who shall conduct an inquiry into the allegations leveled against the petitioner by granting him full opportunity of hearing. Stop. The collector shall pass necessary order in this regard within 2 months from the date of production of certified copy of this order by the petitioner. Yes.
in a play. Though disengagement order has been passed directed to Sarpanch, but yet no disengagement order has
It is
been
submitted that the petitioner is still continuing.
not continue. They are not allowing me to continue.
ତାହେଲେ ଆଉ କିଛି କରିହବନି।
Disengagement order issue ହେଇନି।
ଆଉ କିଛି କରିହବନି। ଏଥିରେ କଣ ଅର୍ଡର ପାସ୍ କରିହବ କଣ? ଆପଣ ଯଦି କଣ୍ଟିନ୍ୟୁ କରିଥାନ୍ତେ ଏଣ୍ଟ୍ରି ଅର୍ଡର କଣ ଥାନ୍ତା ତାହେଲେ ମୁଁ କଣ୍ଟିନ୍ୟୁ କରିଦେଇଥାନ୍ତି।
ଏଣ୍ଟ୍ରି ଅର୍ଡର ଥିଲା ମୋର କିନ୍ତୁ ସେତେବେଳେ ସିଏ ଆଉ ତ ଆଲାଉ କଲେନି କିଛି କଲେନି।
କଣ କରିବେ?
Collector can look to that.
Yes.
How can the collector look into it?
If such an allegation is made before the collector.
Acha, how? It is submitted that no specific order of disengagement has yet been passed against the petitioner by the Sarpanch. But he has not been allowed to perform his duties since then? It is for the collector to look into this aspect and pass necessary orders. Pass necessary orders in course of the inquiry. Yes.
Item number 12.
Lords, the petition from my lords.
No, criminals maybe taken up on Friday.
Next week, Korea. Friday, Korea.
Counter may be of some help to him. Additional counter maybe of some marks.
Mr. Manti, it may help you.
Kindly look.
No, next week. Next,
Thankful to him.
No question, it will be subject to interpretation. But if the additional affidavit means additional counter comes to the amendment, maybe some help to him because he says that I should get promotion. The promotion, the post was made to promote to be filled upon promotion since 2016. Now, my lords to consider he has already availed the benefit, whether he will be entitled to the promotional benefit. If I will put an affidavit, that will be better.
Shri Dhananda Mahapatra requests for an adjournment on the ground that he will file an additional affidavit.
Additional counter.
Additional counter. Additional counter. Let's this matter next week. But next, it will come on 10th July.
10th, 11th, 9th, 10th, 11th, also गाड़ी को बीरा मित्र अच्छी जीविस बॉक्सी को इसको
दाढ़ी रखছেন মানে
ये मोरे मामू दी जण मामू मर जाइछिन गोटे समय
ଆପଣ ତ ସବୁବେଳେ ଦାଢ଼ି ରଖନ୍ତି
ନାଇଁ ସବୁବେଳେ କିନ୍ତୁ ଏ ଦାଢ଼ିଟା ଅଲଗା ପି ରଖିଛି ଏବେ ଆଉ ରଖୁନି
ନାଇଁ ମାନେ
ଏଟା ଆସୁନି 10th 11th
ଦାଢ଼ି ଗ୍ରାଉଣ୍ଡ ରେ ଆଡଜର୍ନମେଣ୍ଟ ନବା ମୁଁ କାହିଁ ଜାଣିନି କାରଣ ଆପଣ ସବୁବେଳେ ରଖନ୍ତି ବୋଲି ମୁଁ କହୁଛି
ମୁଁ ଆକମରେ ଜମା 9th ରେ ରଖିଛୁ
9th ରେ ଆମର ଦେଖନ୍ତୁ ଅଛି ନା 9th
Item number 13.
Item number 13, Milods. On 2/5/24, we have filed the Wakalatnama. We are appearing for the governing body of the institution. Because of the election, Milods, we couldn't file any reply in the meantime. So let it come next week or after 2 weeks, we will file.
But the opinion of Korea is already informed me that he's
who is the petitioner?
We have already taken consent from senior advocate Mr. KP Mishra was there.
All right. You are appearing, who you are appearing for which opposite party?
Opposite party number 3.
Who has entered appearance?
Mr. Bigyan Kumar Sharma.
A prayer for adjournment is made on behalf of Sri Bigyan Kumar Sharma, Learned Counsel appearing for opposite party number 3. List this matter on 24 July. Counter affidavit, if any, be filed in the meantime after serving copy on the other side.
Let's maybe first week of August.
No, 2010 matter. Yes.
Item 14.
My lord, the petitioners, while working under the opposite part number 2, opposite part number 3, in view of the notification under Annex 6.
Opposite part number 3 ki?
SIT. Notification.
SIT. Acha.
They are, while they are working.
Why joint application, Mr. Patnaik?
At this stage, they have disengaged without giving the opportunity. And the interim order was granted, and they have read in the so-called affidavit in contempt. They have filed on the basis of the letter of the Government of India. We have disengaged them. And under the RTI, we have obtained the letter that no such letter has been issued regarding closure of the SIT. And they have also filed an affidavit and begging apology before this honorable court.
All right, please the facts.
I have submitted a note, my lord. I have filed, my lord.
You are appearing for whom, Mr.
Opposite part number 4.
Opposite part number 4.
National Council of Education Research.
NCRT.
NCRT.
And you?
I'm on behalf of Mr. SS Das. That is on sub-item 2.
Sub-item agute chilo.
Sub-item 2, 10985/2013.
NCRT doesn't have any. maximum role in this case.
Yes, Mr. Patnaik.
Note, my lord. The petitioners were engaged as the employees of the SIET after the same was declared as an autonomous body by virtue of the different government orders. All on a sudden, the opposite party observed 48 employees, SIT, in different departments of the state under the veil of deputation list, where the same time they have excluded the 22 employees, the present petitioners, 11 employees.
Was it before me in my previous assignment, this matter?
Good thing.
Okay. I have heard it. मुझे लागू सुनला बोले सिर्फ में. Anyway, please.
Same time, they have excluded 22 employees, including the petitioners, who are similarly situated, and slapped them with an order of disengagement under the graph of closing down the SIT without giving them any opportunity of hearing. Being agreed, the petitioners approach this honorable court challenge the action of the opposite parties mainly on 3 grounds. First, the direction of the disengagement of petitioners by virtue of the letter under Annexure 6, 29th April 2013, by the opposite parties illegal, arbitrary, and discriminatory. Secondly, the letter dated 29 April 2013 or Annex 3 reflecting the closure of SIT is illegal and arbitrary. Thirdly, the opposite parties have created a class within itself by reverting the 48 employees to the SIT as deputation list of the different state government departments, but knowingly the opposite parties have excluded the petitioners with an order of disengage, which are on the same footing under the graph of closing down the SIT. Under Annexure 1, in view of the resolution under Annexure 1 dated 10 January 2020, the SIT was created. The objectives and inception of the resolution with a view to ensuring the effective implementation of the Then, my lord, the Annexure 3, their appointment order.
Annexure 3 is page 31, let us see.
31.
This is relevant. गोटिए तो गोटिए पढ़ दूं
31.
श्री विजय कुमार नंद प्लॉट बोला
Page 31. Sri Vijay Kumar Nanda, 16/11/1987. Sri Vijay Kumar Nanda, Jayadeva Regional Research Laboratory was appointed temporarily on the order as a producer. Then second is petition number 2. All are appointment orders on different years. Robina and Das, page 34.
Okay, so let us go back to your note again.
Then, my lord. Annexure
5, page 62.
Annexure 4. Annexure 4, my lord,
Yes,
page 59.
All right.
May I read the second
Yes.
paragraph?
Yes.
In a meeting, the director mentioned that out of 120 posts recommended by the government of India, the state government created 118 posts, those under whom we have appointed. Post of ET Production Center, SIT and INSAT scheme. Though 118 posts was created, only 63 employees are recruited by the state government and deputed to SIT. Out of 80 employees working at the moment, only 56 of 63 deputed to employees and 24 staff recruited after the upgradation are continuing in the post created by the government.
Just a moment, let us read it again. 118 posts were created. 63 employees were recruited by state government. And deputed to SIT. Out of you are recruited by SIT.
We are recruited by SIT.
That is the difference.
Isn't
it?
Autonomous body.
Maybe that is the difference. So you out of 80 employees working at moment, only 56 of the 63 deputed employees and 24 staff recruited after upgradation are continuing the program. Gola.
Then,
but that is the basic distinction. From state government, some employees were state government recruited some employees and deputed them to SIT. So far as you are concerned, you are recruited, you are appointed directly by the SIT. So what is your claim now?
Our claim is Annexure 6.
You should go back to.
Our claim is when the other employees are posted in different departments and we are appointed since 90. We have not posted in department and without any giving any notice, they have discarded us.
That's a different matter. We will see that.
And those who have deputed to the state from state government to SIT, they have observed in SIT. By virtue
SIT by closure
prior to that.
Let us come to page 62.
62.
This is the policy decision. Absorption of the deputed staff. Please read it. We can read it as well.
With a view to ensuring the quality of educational program.
No, you come to paragraph 3.
Paragraph 3.
On revitalization.
The SIT meeting was held on 15/4/2009 under the chairmanship of the DC and SES. In the meeting, decision was taken to give options to the deputed staff as to whether they want to continue in the autonomous body of SIT and wants to revert back the state government. Then accordingly, Director SIT was requested by this department letter number so-and-so dated 2/7/2019 to furnish the options to the deputed staff. In response to this, 48 out of 51 employees furnished option to revert back the state government. To look into the details, an in-house committee was formed by the S&M department since all such posts are available.
Are not available
in the directorate, and field officers under the SSM department, other line departments were requested to furnish the vacancy position under their control to accommodate both technical and non-technical employees. We are also technical non-technical. On receipt of the vacancy position, different departments, and that is P and IR departments, Science and Technology department, Culture department, Directorate of SIM department, as per the
in-house committee observation, government of
in-house committee of reservation, but government after careful consideration had decided to absorb them in the different departments and directorates, keeping in view their post grade in the following manner. These are some different departments they have adjusted. The page 64. Page 64.
List the
Santosh Kumar Sahu, who was appointed on the autonomous organization, they have also adjusted.
Santosh Kumar Sahu.
My lord. Is the Director Elementary Education. Bringing up Director Elementary Education. Serial number 4. They have also adjusted. Then, my lord. Annex 6. Improving order.
In persons for order number 8.
Page 67, madam.
21 out of 20.
In pursuance to order dated 29/4/2013, SIT Odisha Bhubaneswar has been closed with effect from 29 April 2013. 21 out of 22 number of autonomous employees are to be disengaged with the effect from 29/4/2013. For disengagement of Vishwasundar Roy, Assistant Storekeeper, SIT, you are requested to take necessary step to vacation of the stay order given by the Hon'Ble High Court in position of so-and-so. The services of Roy is placed on the disposal of the Director, TE and ACIT until further orders. And within 21 we are here. 11. No opportunity is given, and on the same day, and your lordship permit me to read the interim order. Dated 15 May 2013. In the interim, may I read matter? 15 May 2013.
Order number?
9.
15th May 2013.
My lord. First order.
Yes.
In the interim, in the interim, if the petitions are continuing under SIT in their services, they shall not be disengaged without leave of this court, and their salary be paid to them regularly during pendency of the petition. It is also directed that if the state is proposing to close down the SIT, such order closing down of the said institution shall not be implemented without leave of this court. And thereafter, my lord, we have filed a contempt application.
Why? Why did you file?
Because they have not paid our salary, and in the show cause affidavit, my lord, they have stated that on the basis of Government of India letter, we have closed down the SIT. And we have filed an affidavit that under the RTA we had obtained the document that such type of letter has not been issued by the central government. And thereafter, the apology was made by the secretary at that point of time.
So what is the factual position now?
The actual position, they have SIT building is there, and they are occupied by the government. And till today, no compensation has been paid to us.
Why compensation?
Because without any notice, they have disengaged on the same day. And the some employees who are appointed under the autonomous
I want to
organization,
know what is the status of SIT?
It's already been handed over.
that the government has handed over SIT to another department. The moment the order was passed, on the next day, they have handed over to other
Skill development department. Skill development.
other agency under the control.
Who is appearing for SIT?
The state government has filed counter on behalf of the.
Let us know the initial response of the state. Yes, Mr. Das.
Yes, paragraph 9 of the counter affidavit is the stand of the state government.
Paragraph 9.
Yes.
Your opposite party number?
The counter affidavit by opposite party number 3.
Number 3. Yes.
That SIT was being funded under the centrally planned scheme.
Yes.
With 100% funding from Government of India. Government of India had been sanctioning fund in favor of SIT through the state government, which was being routed through the budget of the state under central plan scheme till 1999-2000. Thereafter, no budget provision under the central plan scheme was made by the state government for SIT. Since 1/1/2000, Government of India had been providing funds to SIT directly instead of routing the same through the state government. The Government of India in letter dated 24/12/2004 requested the state government to take maximum use of the services of the SIT as this will help them financially viable. The Government of India further requested the state government to recall their staff on deputation to SIT within a period of 3 months, failing which the salary of the personnel will not be funded by the Ministry of HRD. The Government of India in their letter dated 25/3/2005 further reminded to withdraw the state government staff on deputation to SIT. Government of India will not be able to pay salaries to them after 31/3/2005. The Government of India had not released salaries since 1/4/2005 in favor of the staff of the SIT. However, the state government has been paying salary to the staff out of the state plan since 2005-06. The budget provision for this purpose under the School and Mass Education Department for the last 3 years has been as follows. That has been given. So that is the stand.
No, Government of India is no longer funding it.
Yes.
State government has been paying it, paying the salary and etc. from its own funds.
Yes.
But what is the current position? What is the stand of the state government with regard to the continuance or otherwise of that institution? That is not clear.
That of course has not been.
The meeting is 15/4/2000 planning and coordination. Plan fund should not ordinarily be utilized to pay salaries and wages. Administrative department may explore other options, including meeting such costs out of resources generated by SIT staff. So there is nothing on record to show that a decision was taken to close down. This is one part that the state government took back its employees.
Yes.
Who were deputed to SIT. One of them happens to be a person engaged by the SIT according to, as Mr. Patnaik has pointed out. So this order of disengagement, this has been passed in respect of all the
petitioners.
So 24 employees were totally engaged by SIT.
SIT.
So far as the petitioners are concerned.
Petitioner 11.
But 24 employees.
Other petitioners are there.
So 24 total. 22.
22. 2 persons are died.
Achha, 22. So 24 were recruited and 22 are available. What is going to happen to them? That is the only question to be decided.
Sir.
In the year 2002, the employees who are deputed from state government to SIT, they have given an option and became the employees of the SIT in the year 2002.
Yes.
All the employees of state government who are deputed, they are the employees of the SIT, including the petitioners. And
but you are different.
We are the all employees of autonomous body SIT. But when they deputed again 29/4/13, prior to that in the 2012, they have deputed that employees who were come from the state government.
No, in paragraph 15 is very important. It says that it has been releasing idle salary without any work being done by you.
In the year 2014, central government was grant 44 lakh. 44.
No. I mean, if you are not doing any work, why should the government pay you any salary? And Mr. Das,
sir,
in this regard, if the government has no further work for them, the government can sever them. I mean, can
engage them,
give them severance pay, either engage them or give them severance pay, compensation, etc., and remove them. That's all. Closure of establishment is also provided under the law. There is a procedure to be followed.
Let me take the up-to-date instruction as to what
I will ask you. In course of hearing, attention of the court is drawn to the amendments taken in paragraph 15 of the counter affidavit filed by opposite party number 3, wherein it is stated that the government has been releasing idle salary as idle salary, which is causing a burden on the state exchequer. Further, the building and land are lying unused. If such is the situation, this court would like to know the decision of the government, if any, with regard to the future of this organization. And in such a situation, what would be the fate of its employees? List this matter on 14th August. We can take it on 31st July. Yeah, list this matter on 31st July.
So
the State Council may file an affidavit in this regard. You get the point?
Sure.
You see, you have no work. You have no work for them. Remove them in accordance with law. Pay them compensation. Sola matter.
Either.
जो माने government employee थिले ताकरो से फेरी गले. ये माने तो government employee. Yes. I think that should be the best option. If there is no work, no court can direct them to be employed forever. Yes.
My lord, although intelligence is not that urgently required, but a copy of the counter filed by the opposite party note 3.
Yes, let pleadings be expressed. Have a good one. Reference may see it will for hearing it will go back to contempt is being taken by the court of by Honorable the Chief Justice. Yes. I don't know 15. केतरा अछि
Lordship kindly.
Yes.
Lordship was pleased to allow me to conduct this case. And your Lordship was pleased to pass an order on 8/5/2024.
Yes.
directing the state council
Completion of the
to take
procedure,
instruction.
on the ground of non-availability, was absence for allowed one Gunanidhi Bhoi to be appointed, though he had secured less.
Repressing your lordship's memory, my lord. Yes.
I've read my order.
Yes.
That
She was.
fact remains that there were vacancies available at the time of issuance of the second advertisement. The question is if the petitioner had been selected in the first selection process and secured more marks than Gunanidhi Bhoi, why was she not considered?
After this order, my lord, we have written the letter to the authorities. We have not received any communication, but the counter and the pleadings, along with the supporting documents, my lord, whatever it is available presently at the moment before lordship, my lord, those are sufficient to reply that. I can answer that.
Yes.
Yes. My lord, in this case, in 2014, advertisement was issued.
Yes, sir.
Yes, sir. Petitioner applied for it. She was at that point of time, she was BA qualification, but B.Ed she has appeared. The result was not declared, and she has also completed OTET. She applied, and as per the advertisement, a candidate must give the specification. She has given first preference to Puri and thereafter Khurda and other high specification. Thereafter, the draft list was published. Her name was found placed on item number 130 in the Bhadrak, in the district of Bhadrak. My lord, 15 districts, the advertisement was meant for 15 districts. So Bhadrak 130, where there is no post for female SC category, but she has been enlisted under 130. Thereafter, she filed a representation also, stating therein that in the meantime she has passed the B.Ed qualification, B.Ed exam, and she has given the preference at Puri number 1. The vacancies are there, therefore she may be accommodated. Nothing has happened. Thereafter, by virtue of the order of this honorable court, the second, my lord, another advertisement was issued for the persons, those who were overaged. But in that category, I was not eligible to apply because I was in the first category. So she could not. Thereafter, she filed this petition before your lordship. Her prayer is twofold: either to give her appointment in the Puri, where vacant post are there, or to allow her to appear in the second. Appear in the second for the second notification. That is no more there, my lord. But your lordship was pleased to pass an interim order, keeping a post vacant. My lord, this is, and the counter affidavit has been filed, stating therein that for the Puri, a person was selected who didn't join. Thereafter, another lady was selected who has secured more marks than the petitioner. But they have concealed that one Gunanidhi who has secured less mark than me has been accommodated pursuant to the second notification. And your lordship may kindly see the counter.
Have you said so in your rejoinder about that Gunanidhi?
Further affidavit they have filed.
No, Gunanidhi kotha कहले हाँ कहछि. So what did they say in the reply?
Their reply is that the lordship may kindly turn to
Gunanidhi kotha लिखिसेंती.
page 3 of the counter. They have not stated anything Gunanidhi.
कहछि ना?
ना.
तारा 5 रे कहछन.
Kuta.
जे से तो फर्स्ट प्रेफरेंस डिस्ट्रिक्ट तंगर पूरी थिला ओवर एज कैंडिडेट हिसाब रे.
Counter affidavit.
No, reply to the rejoinder.
Reply to the rejoinder कहछि.
So how to get out of this now? There is a vacancy. There is a vacancy. Now, what is your stand? Tell me.
My lord, with respect to the existence of the vacancy, my lord, I do not have specific information, though in the last occasion, my lord, in another case, with respect to the status of the vacancy of the on-field vacancy of 2016, while referring to that Mamta Naik case and other. We have got some information that in the meantime, advertisements have been issued taking into consideration the backlog vacancies. So, without going to that matter, before going to that particular point, madam, if there is a vacancy, whether the petitioner has a case or not, madam, that is to be seen. Madam, advertisement was in the year 2014, madam. That particular advertisement, madam, didn't consider the case of the persons who are already overaged. So they appeared before this honorable court, madam. Taking into consideration the decision of the honorable court, another corrigendum was issued, madam, that is Annexure 7 to the present petition. Now, that corrigendum at Annexure 7, madam, that consists of certain conditions. Let's come to Penor 41.
Yes.
Madam, in the first para, the last few lines, the last line, the candidate, those who come under the age group of 35 to 42, with such relaxation can only be eligible to apply afresh, who had not applied for the post of Shikha due to overage and responsibility.
So this does not concern the petitioner.
No.
She was not over, she had already applied.
Now, my lordship may come to, thereafter, the next para is this relaxation of age. Then the district-wise vacancy. The district-wise vacancy will be available in the website for information of all the candidates, and each candidate shall exercise maximum 2 options. But in the previous occasion, it was five options. Now it has been limited to 2 options. The merit list will be prepared combined in.
No, obviously, this exercise of 2 options is limited to the candidates for whom it is not for others.
Because, my lord, already in that particular process of selection, the lists were prepared. And when lists were prepared, and by that time, my lord, first, second, third pages of the list, my lord, that has been exhausted. So what is the next parameter that is most important? The first parameter, the district-wise vacancies will be available in the website. Then the merit list will be prepared, combinedly district-wise, after considering the merit of the candidate who have already opted for 4th and 5th preference, according to the previous advertisement, along with the new candidate who will opt for the 1st and 2nd preference of the district. So, that particular merit list with respect to 4th and 5th preference and 1st and 2nd preference of the new merit list. So a combined merit list will be there, but by that time, my lord, the up to 3rd phase of selection, my lord, that was already over. So such a stipulation was very much made, my lord, taking into consideration the direction of the honorable court, and an advertisement was issued granting the relaxation of rates. Now we have clarified that position in our counter. If a lordship will come to the counter, there we have stated, my lord, initial in para number 4, that the petitioner had applied as a +3 on trend under the scheduled caste category, and petitioner number at the para number 5, my lord, it is admitted that treating her as +3 arts on trend candidate, she has secured 86.3690% of mark without training qualification. Then lordship may come to the next para. The testimonial and the certificates was fixed for 29/10/2014. Those who have opted for the first preference at the Puri, my lord.
What was your first preference?
Puri. Then, my lord, at the time of verification, and when, because she had submitted an undertaking, my lord, that I have already appeared in the examination, but the result is yet to be published. So that was not taken into consideration, and that is indicated in para number 7, but that was not accepted, my lord. That is available in para number 8. Then, my lord, para number 9. The government in SNDM department, my lord, advertised 61 numbers of Shikha posts in +3 arts train category for Puri Revenue District. As per the ORB Act, out of 7 number of posts reserved for SC open category.
Subsequent advertisement?
No.
First. Original advertisement.
3 number posts are SC female category. As per the merit, 7 number of SC women and 3 numbers of SC female having training qualification candidate was placed in the merit list, and the cutoff mark is 181.617 SC open and 149.669 in SC female trained category. Accordingly, after verification of the testimonials, DPO SSA Puri, the engagement orders were issued in favor of those. So, my lord, admittedly, my lord, the petitioner, not only she is a non-trained candidate, but also she has secured less percentage of mark, my lord. So, for the first preference is concerned. Then, para number 11, my lord. After issuing the engagement order, one Surekha Bala Behera from SC female category bearing application didn't join in her post. As a result of said, post was lying vacant. After the said vacant post has already been filled up by one Krishnapriya Jalli in the merit list of SC female category, untrained category of the said merit list, and she had secured 158.931%, my lord. Then, my lord, we have stated that, my lord, the petitioner secured less percentage, and then the untrained candidate Krishna Pejali, for better appreciation, my lord, we have given second phase of first preference of Puri, and, my lord, with respect to the fourth preference, that is at Bhadraka. My lord, with respect to that, my lord, we have stated, thereafter, my lord, we have clarified that after this particular re-advertisement and the selections were made, the petitioner could not be appointed in that project. Now, with respect to Gunanidhi Bhoi, my lord, what they have indicated in the rejoinder, my lord, we have stated, my lord, in our reply. That is in para number 4, para number 3. Engagement order has been issued in respect of one Gunanidhi Bhoi under +3 as untrained SC UR category on 28/3/2016, who has secured 83.054%,
which is less than the petitioner.
Less than the petitioner. It is pertinent to mention that out of the 6 number of posts lying vacant in Puri district against 4th preference district, plus the state project office, OPEBA, Bhubaneswar provided the eligible list of the candidate of 4th preference district, in which
just. I will read it again. There were 6 number of posts lying
vacant meant for +3 arts SC UR category.
SC Puri UR category.
Actually, seman mojire lepchon SC open body. SC open means what I could gather the information that women category, they can compete with the
SC UR pun likha bolo confusion hone. SC pun UR.
Se SC UR agar through election the SC UR. Open SC open.
All right. Man general jo SC ka ye hoga without women or but horizontal part of
anybody can count.
Horizontal reservation part no likhi hoga. Acha ho. In Puri district
your category in Puri district against 4th preference district. The state project office OPEPA Bhubaneswar provided the eligible list of the candidate for 4th preference. A paragraph of whatever relevance I had taken lordship to that particular paragraph of the advertisement, wherein the combined list, merit list is to be prepared, taking into consideration the 4th and 5th preference and the first and second preference of the new. So, this particular number, para number 4, my lord, that says that provided the eligible list candidate list of the 4th preference of district Puri. Its submission is with respect to Puri district matter, where Sri Gunanidhi Bhoi opted for first option over S. That means, my lord, the first and second option are combined list in his online application form, and his name was placed in the said eligible list, where the name of the petitioner not placed as the petitioner opted for 4th preference in the register of Bhadraka. So, in this process, my lord, at the time of consideration of the combined merit list, in terms of the second advertisement, the district-wise merit list was required to be prepared. In terms of that advertisement, that advertisement was never under challenge, my lord. And a merit list has been prepared accordingly, taking into consideration.
Let us read the advertisement again. That corrigendum.
Yes.
Where is it? Annexure 7.
Annexure 7.
Yes.
Page 41.
the district wise, the merit list will be prepared combinedly. District wise, after considering the merit of the candidates who have already opted for fourth and fifth preference, along with the new candidates who will opt for first and second preference. Of district respectively.
So since the petitioner's option for the fourth preference is for Bhadrak and Gunandi's first preference is for Puri. So that cannot be compared. That is what the stand of the respondent in this case. Because your lordship put me a question on the previous occasion that how it could be. So because I got these informations, even though I have not received any specific instruction from the authority.
Appears to be iniquitous.
But that is in terms of the advertisement.
Advertisement, certainly.
I think my lord, till filing of the writ petition, the post were lying vacant. For which your lordship was pleased to keep a post vacant. So where is the scope he is trying to, my lord?
But even if the post is lying vacant, but there is no evidence to that effect that in the preference district, where the petitioner's case is to be considered, a person securing less mark in terms of the advertisement has been applied. So even if a vacancy is there, there may be some other person also in that category.
If there what they are aware, why they have not filled up the post vacancy? If they are aware.
Because the vacancy remaining, the post remaining vacant till date.
Yes.
Or till the date of passing of the interim order by this court.
Yes.
This raises questions. Because your idea with this preference thing is what? It is the basic idea is to see that people get representation all over the district, all over the state, as per their own preferences. Vacancy किंतु है वो तले. तो जो भी vacancy थीला, तो यहाँ को भी दिया जाता.
Actually, I'm not prepared on that particular question because even if my order sheet does not reflect that there is an interim order keeping one post vacant.
No, she's saying that
I'm not disputing it, but
that's what I have been instructed.
Let me see. Let me see.
Yes. That's what I have been instructed.
All that is separate issue notice.
No,
more it is.
भी जाननी मक्ते जहाँ instruction हो कुछ.
ये सारा dismiss की to non-prosecution. I don't know how. When was it restored?
The person who filed, she died. The lawyer. Thereafter.
No interim order.
Interim order. But I have been instructed that there is an interim order to keep a post vacant.
No, there is. I did not find any interim order. You can check the file also. It's better if you check the file.
I'll check.
Heard in part. Learned State Council, Sri Patnaik Learned State Council shall inform the court as to if any vacancies are presently available in the district of Puri or
85
or Bhadrak.
One of the
Bhadrak रे बिल्कुल post
or in any of the five districts preferred by the petitioner.
She has opted for.
By the petitioner. Yes. Let's this matter on 24th July.
Oblace.
Item number 16.
16 today I filed the rejoinder copy already. Yes, my lord, a rejoinder copy has been received. They have disputed the stand in the counter affidavit that was filed. So let me check the further instruction.
Learned counsel to the petitioner files rejoinder in the court after serving copy on this state council who wants to take instructions on the amendments made therein. List this matter.
24th July.
On
31st July.
31st July. Item number 17.
I'm on behalf of Mr. Nanda, my lord. His brother-in-law passed away today morning, my lord.
Okay.
Let's not keep it any other day.
Therefore, adjournment is made on behalf of Sri Nanda, learned counsel for the petitioner on the ground of bereavement in his family. List this matter on 10th July.
After 16, my lord.
On
16 or 18.
On the 24th July.
Yes.
Yes.
Number 18. My lord, I have filed the chronological dates of events and written note of submission.
Yes.
Like the petitioners have claimed in this writ application to treat the petitioners as Sikha with effect from 2/1/2008. That is the date on which persons having lesser merit in response to the selection made pursuant to the advertisement itself is issued for engagement of Sikha were appointed engaged, and to treat the petitioner as junior teacher with effect from 2/1/2011 and regular primary school teacher with effect from 2/1/2014. 31/5/2006, the state government issued a resolution in relation to the engagement to the post of Sikha Swag. In the said resolution, it was
Sir, I think you can just briefly tell me the facts without going through the entire note.
My lord, we are candidates for the advertisement issued by the authorities as Sikha Swag. The principle and the law was the selection was to be made taking district educations as the unit. However, they did not take the education district as the unit. They took it as the revenue district as the unit.
Have I heard this matter earlier?
My lord, it has come before my lord's number of times.
Yes.
Because on the last.
Oh, there was a dispute relating to that revenue district ki education district Nimapada group.
No, this is Balasur.
Then Nimapada group dispose of
it will come now because it was in a different bench. I raised objection that that's not the assignment bench, so it will come to the Central Court. Yes. The issue almost the same, sir. Issue is if it is to be taken as the education district and the selection was made by the revenue district there, that was taken by the block wise. And thereafter, 2 or 3 litigations were there continuously, one after one. Ultimately, my lord, they issued the engagement order. They issued the engagement order pursuant to an order passed by this honorable court in the year 2016. But the engagement order was issued with effect of the date the order was issued and treating me as we have 2 to 3 persons, as junior teacher contractual. We never applied for junior teacher contractual. That was never the issue before this honorable court. Issue before this honorable court was, as per the selection made in the year 2008, where you are the candidate, less merited student than us have been given appointment because you have taken as the revenue district as the unit instead of the education district as the unit. Your Lordship knows, in one revenue district, there are 3 or 4 education districts consist. The fact the education district would have been taken into consideration, as per the merit prepared within the education district, would have been eligible. And in fact, after lot, the district, the opposite party number 3, the collector cum chief executive officer, passed an order to engage us, but with effect from the date that was appointed. My lord, this law has been established by the apex court. My lord, I have given that, your lordship can have it that in the judgment at running page. Your lordship will get it. IN number 1811114 of 2022. Annexure 9 at page running page 5.
Yes.
Shaktipada Mahapatra versus state. Your lordship must have seen it a number of times. Their lordship said that I will place only 3-4 paragraphs of that. Can lordship will come to page 11 of that judgment of Supreme Court. In the given facts and circumstances, once the appellant has secured higher marks, as has been reflected from the record, there is no reason forthcoming from the respondents why the appellant was not considered for appointment, despite being placed higher in the order of merit vis-a-vis the appellants who had participated along with the appellants and were appointed in April or November 2007. This is related to 2008, my lord. The only justification which has been tendered by the respondents before the High Court and also before this court in the counter affidavit filed on behalf of the respondent number 1 to 5 is that the clarification was made by the government of Orissa
Department of School and Mass Communication dated 22/11/2006 that while awarding grace mark to various categories of applicants, such of the applicants who had earlier served as a para teacher of DPEP and FA and NFI and NFE, etc., marks shall be added above to the minus can skip over can come because it has no bearing to paragraph 12. The justification which has been tendered by the respondents is wholly without substance for the reason that the criteria for determination dated 14/10/2006, of which a reference has been made, and the clarification regarding computation of the marks of Shiksha Sahayak in 2006 by the government further strengthens the resolution of the government was that grant of grace marks as notified under the advertisement has to be strictly followed, and mere converting marks secured by the applicants on the basis of the academic record and experience into the percentage would not in any manner be made prejudicial to the interest of the applicant, who is the determining factor for assessment of merit, etc. This was neither considered by the learned single judge nor by the division bench under the impugned judgment. One of the options this court has earlier to remit the matter back to the High Court to revisit the materials on record and examine the grievance of the appellant on merit. But looking at the manner in which the matter has been dealt with by the High Court, of which reference has been made, this court considered it appropriate to look into the grievance of the appellant and pass appropriate order to meet the legitimate grievance of the appellants. Once the fact has been established that there are lower in order of merits, respondents 6 to 9, imprinted in the High Court, were appointed by an order dated 23/4/2007 and 16/11/2007, respectively. And the duty and the only criteria for determination of merit was academic record and experience, as was notified in the advertisement of 2006, of which a detailed reference has been made. We find no reason to deny the legitimate right of the appellant from being considered for appointment to the post of Shiksha Sahayak, to which he was otherwise eligible in terms of the advertisement. The further defense of the respondent is that since the scheme has later been abolished, would be of no significance, particularly when the other applicants, respondents 6 and 9, implemented before the High Court, who had participated along with the appellant by pursuant to the advertisement dated 14/10/2006, were appointed as Shiksha Sahayak by order dated 23/4/2007 and 16/11/2007, and were later on regularized as teacher by order dated 18/11/2013 and 22/8/2014, respectively. Consequently, the appeal succeeds and allowed. The judgment and order dated of the learned single judge dated except division bench are stated aside. The respondents are directed to consider the case of the appellant and appoint him as Shiksha Sahayak on notional basis pursuant to the advertisement dated 14/10/2006 within a period of 1 month from the date. The appellant shall be entitled to all the notional benefits, etc., etc. Now they have appointed us pursuant to the advertisement because we have never applied to the post of Shiksha, that is junior teacher contractual. And they have written that the order indicated pursuant to the order passed by this Honorable Court in 2016. 2016 order, Milos, to see it more, Milos can have a look to the order that was passed. You also will kindly get it at page 73, Annex 8 series at page 71.
Yes.
Compliance of this was given in the compliance affidavit. Compliance of the order of the Honorable High Court in WPC number 65006 of 2016, consequence of execution of agreement dated this August 20 between etc. The collector, it is hereby engaged as junior teacher contractual. Minus for junior teacher contractual was separate advertisement made. We are never party to that. And 2016 order, you also will kindly get it at Annex 6 at page. It starts from page 58. The order is at page 61. From the directions contained in the dispose of the writ petition by the division bench of this court, there remains no dispute that the circular in annexure 1 is not only reaffirmed but has been brought into force. Considering that the petitioner application was in terms of resolution of 2006 and further taking into account the directions of this court in single bench on the disposal of this case number this of 2015, this court again finds there is a clear direction to the state authority to consider the representation of the petitioners, keeping in view the decision of this court rendered in the case of Chandramani Jena versus etc. 2007, volume 2, LR 577, as finds place in annexure 3 for the development in respect of the writ petition by the division bench as well as in the missed case by the single bench. This court is of the opinion that the representation submitted by the petitioner number 1 by the annexure 8 should have been considered only keeping the view of the circular of 2006 at annexure 1 and the order passed by the division bench as well as single bench indicated here in above. Considering the submission and the counter.
I get it. Tamil, so this was the direction, but the order according to you was passed
in 2020, taking me as junior teacher contractual, thereby delaying the benefit.
Presumably because there was the scheme had been abolished by then.
My scheme has been abolished, but as per the Honorable Appeals Court order, if this when we are appointed, we are in the merit list, and we are to be appointed to the post Act.
No, sir. I'll just ask you to pause for a moment, sir. You may have an objection with regard to the nomenclature, but your main prayer is that your previous engagement ought to have been considered.
Yes,
the notional or whatever.
Yes.
So whatever may be the nomenclature, they may hold you junior teacher contractual or Sikha Sahayak or whatever.
Even IMILs have categorically said, can have a look to my IA.
All right, we'll continue after.
Yeah.
After recess. We'll continue. Some other day.
Sir?
But one thing I would like to bring to your lordship's notice, at page 13, the Honorable Supreme Court's directive in the SLP.
Yes.
Consequently, the appeal succeeds and is allowed. The judgment and order dated 24/6/2019 of the learned single judge dated 14/10/2019 of the division bench of the High Court are set aside, and the respondents are directed to consider the case of the appellant and appoint him as Sikha Sahayak on notional basis pursuant to advertisement dated 14/10/2006, within a period of 1 month from today. The appellant shall be entitled to all notional benefits and other directions were given. Now the counter affidavit has been filed, having been filed not by the state government but by the by district education officer.
Okay.
I will have to take further instruction.
Even if suppose minors maximum, they can take that the ratio of notional benefit can be extended to me. If that notional benefit is to be extended, I'm supposed to give, if such a plea is taken, my appointment is to be taken with effect from the date the judges have been appointed. And I have got schemes, my lord. 3 years after the appointment as Sikha Sahayak, one will become come as a junior teacher. And 3 years thereafter, as a regular primary school teacher, the day I became a regular primary school teacher, and till today, there are so many promotion benefits. I have explained it to my IA. If they extend it, I have no difficulty, sir. Because I cannot claim. But as directed by the Honorable Appeals Court, I am entitled to the benefit. He cannot have any grievance with that.
No, let him open instruction.
After the directive of the Honorable Supreme Court, no grievance.
So because that is settled.
Law is settled.
So nothing can be done about it.
Yes.
So all right, we'll keep it parted and we'll keep it to some other day. You will obtain instruction. We'll find it. Hard part. Sri Adas Leonard AGA requests for some time to obtain further instructions with regard to the claim of the petitioner for his appointment notionally as Sikha Sahayak prior to his appointment on
They have given totally.
Notional that will take care of it. Release this matter on 16th July.
Yes.
Yes.
With your lordship's kind permission, next item. Today I am not feeling well. Can it be taken up next week? 19. Hon'Ble. 19 next week.
The case of open number 6 is that he has appointed as a PT in Kaptipada College, Kaptipada, and he continued. The college got recognition, recognition.
For the managing committee?
Yes, for the managing committee
Yes.
also. So the college has he got the air, and from the date of appointment till date he has been continuing as such. But the petitioner has come forward and filed the petition that he has been appointed and he was not permitted to work, discharge his duties, for which he filed an appeal before the director. And the director allowed the appeal. Being aggrieved by the order of the director, the governing body, and myself being open number 6 in the present case, approached the Honorable High Court. Honorable High Court heard the case and directed rehear the case. And again the case was heard by the same director. And the director held that he should, the appointment should have been given to open number 6, and he should continue there and allowed our case. So here, being agreed by that order, he has approached to this honorable court.
Yes.
He says he has been appointed and his service was terminated because he was not permitted to work. But the rule says within 30 days from the date of termination, if that is he is not permitted to treat it as a termination, and he will approach to it. After 2 years, he has approached, and the reason is not there. So I want to tell minors, the case of the open number 6 is on 13th 10th 86. Minors, the open number 6 was appointed. On 15/11/86 he joined, and on 7/7/90 he went for separate training. But here the important thing is separate training. He went for separate training with the permission of the managing governing body. And after the completion of the training, separate training, he came and joined in his own post. During this gap, they gave appointment to petitioner only just to manage the matter because he is absent. He remains absent. He has gone for training, and he himself was also on trained. And thereafter he was sent for training. After he came back training, then after 2 years, he approached, he filed the appeal. If his service has been terminated without following the due procedure or natural justice, definitely he should have gone within 30 days or thereafter. No reason has been given there. No reason has been assigned there. But he tells that he was not being permitted and he did not go. My lords may kindly see, I am submitting, I do not want to waste my lord's time, but I want to pray to see some documents which I have collected and approached to my lords. My lords, Dismissal will get it. This is the first letter, this 21/10/86, there was an interview, and petitioner appeared in the interview along with me, and I stood first, and he became second. So I was given appendix, my lord. My lords, This is the resolution dated 24/12/86, my lords may kindly षष्ठ प्रस्ताव this is resolution governing body. Sri Ramchandra Mahakur myself PT नियुक्ति संबंध रे पूर्व प्रस्ताव अनुसार महाविद्यालय जने PT श्री रामचंद्र महाकुड़ नियुक्ति होइथिबार ओ उक्त व्यक्ति कार्य योगदान थिबार सूचना संपादक देले ओ उक्त नियुक्ति को अनुमोदन करबे प्रस्ताव आगत कले यह विधिवत आलोचित होई गृहीत हैला से अणतालीम प्राप्त होइथिबारु आगामी 4 वर्ष मध्य तालीम प्राप्त होई प्रमाण पत्र उपस्थापित करिवे निर्देश देवाक बैठक सर्वसम्मति भाव संपादक को क्षमता प्रदान कले आगामी यही 4 वर्ष मध्य जदि से निजर तालीम प्रमाण पत्र देवाक अक्षम हंती तेबे तांको कार्य बहिष्कार करने संपादक को क्षमता प्रदान करागला माइनर्स within these 4 years I also completed my training and I came back minors में कहते हैं next minors that is the resolution dated 2/87 minors पंचम प्रस्ताव this is important for me minors पंचम प्रस्ताव did I not get it पंचम प्रस्ताव
ता सही resolution
no another resolution minors another resolution dated
हाँ ठीक है yes
87
yes no अच्छा रंगाधर पाइकराय को पीटी तब पदवी रे नियुक्ति संबंध
महाविद्यालय जो श्री रामकृष्ण महाकुड़ पीठ भाव महाविद्यालय जोग देइथिले ही ट्रेनिंग हासिल करि नथियारु ताकु सीपेट कोर्स ग्रहण करि नथियारु ताकु छुट्टी रे स्टडी लीव पाई उक्त
को प्रस्ताव पढुछन आपण
माइलर्स आई एम रीडिंग 2989
अच्छा
पंचम प्रस्ताव
नहीं पंचम प्रस्ताव ता 2287 रे अछि
आगे
2287 रो पंचम प्रस्ताव श्री रंगाधर पाइकराय को पीटी पदवी रे नियुक्ति संबंध है
सर
नवम प्रस्ताव
आपण जा डॉक्यूमेंट दैछन सेकंड रेजोल्यूशन
माइलर्स श्री रामकृष्ण महाकुड़ सीपेट कोर्स समाप्त करबा कोई
ना सेकंड 2287 रो
श्री रंगाधर पाइकराय पिटिशनर पीटी पदवी नियुक्ति संबंध महाविद्यालय पूर्व नियुक्ति प्राप्त पीटी श्री रामचंद्र महाकुड़ माई सेल्फ अणतालीम प्राप्त होइथिबारु तालीम प्राप्त हेबा पई छुट्टी जीवा पई संभावना थिबा हेतु विकल्प स्वरूप श्री रंगाधर पाइकराय पिटिशनर को अस्थायी पीटी नियुक्ति देथिबार सूचना संपादक बैठक रे उपस्थापन कले से पाइकराय संबंध में परवर्ती बैठक रे आलोचना होई सिद्धांत ग्रहण करिया पे निष्पत्ति निया गला उक्त श्री पाइकराय से मध्य अणतालीम प्राप्त थिबारु तालीम प्राप्ति पर कार्य जोग देबा पे सबरे स्थिर हला दिस इज द all about his appointment by God. Because I was allowed to go for training, he was allowed to remain for temporary period.
All right, then 89
नवम प्रस्ताव श्री रामकृष्ण महाकुड़ को पीटी स्टडी लीव मंजूरी संबंधी श्री रामकृष्ण महाकुड़ पीटी भाव विद्यालय जोग देइथिले ही ट्रेनिंग हासिल करिनथिबारु ओ सीपीएड कोर्स ग्रहण करिनथिबारु से छुट्टी रे स्टडी लीव जाई उक्त कोर्स संपूर्ण करिया पई आवेदन करिथिबा विषय संपादक बैठक रे उपस्थापन कले यह आलोचित होई सर्वसम्मति क्रमे निष्पत्ति ग्रहण करा गला ओ तांकु एथि पई 1 अगस्त 89 10 मास छुट्टी देवा पई संपादक को क्षमता अर्पण करा गला उक्त ट्रेनिंग पीरियड रे तांकु वेतन कॉलेज रे देवा पई सिद्धांत ग्रहण करा गला आफ्टर माइनर्स 2990 माइनर्स रिजोल्यूशन 2990 षष्ठ प्रस्ताव did I not get it?
Yes.
ଶ୍ରୀ ରାମକୃଷ୍ଣ ମହାପୁର myself CPR କୋର୍ସ ସମାପ୍ତ କରି ନିଜ ପଦବୀରେ ପୁନଃ ଯୋଗଦାନ ସମ୍ବନ୍ଧେ ଶ୍ରୀ ରାମକୃଷ୍ଣ ମହାପୁର CPR ଟ୍ରେନିଂ କରିବାକୁ ଛୁଟିରେ ରହିବା ପରେ ଉକ୍ତ ଟ୍ରେନିଂ ସମାପ୍ତ କରି ନିଜ ପଦବୀରେ ପୁନଃ ଯୋଗଦାନ କରିବା ବିଷୟ ସମ୍ପାଦକ ଶ୍ରୀ ମହାକୁଡ଼ ବୈଠକରେ ପ୍ରକାଶ କଲେ ଏବଂ ଉକ୍ତ ବ୍ୟକ୍ତିଙ୍କ କାର୍ଯ୍ୟରେ ପୁନଃ ଯୋଗଦାନକୁ ଅନୁମୋଦନ କରିବା ପାଇଁ ପ୍ରସ୍ତାବ ଆଗତ କଲେ। ଏହି ଆଲୋଚନା ହିଁ ସର୍ବସମ୍ମତିରେ ଗୃହୀତ ହେଲା। I was permitted to join after completion of training. My lords, here, last my lords, that I am the teacher attendance register, my lord, there. November 1986, my lords. Next page, my lords, R.K. Mahakudu. My name is there. I am the teacher of that school and I have put my signature there, my lords. And I have my name was just sent and I have been paid salary. I approved my serial number 8 PET. Ramakrishna Mahakudu. I got salary 1 So my lords, the entire thing I would like to say and submit very shortly that I have been appointed by following due procedure of law. That is the interview. Secondly, I have been appointed because of want of my qualification, governing body permitted me and I went there. And after that I joined it. Everything has been done as per the law, as per the rules, where nowhere I have deviated anything. But he comes forward and say,
no, I have one or two questions to you, Mr. Patnaik. First is, we come to this resolution which was passed on 2/2/1987.
My lords. पंचम
प्रथम जो आपण देले रिजोल्यूशन टा सेटा आपण देले 24/12/1986 बोधे 24/12/1986 सेथिरे प्रस्ताव हला जे जेतु से अण तालीम प्राप्त तेणु तांको 4 वर्ष भितरे तालीम प्राप्त होबा को पड़े। On that basis, on 2/2/87 ये जेतु माने याको बदल रे माने in your place the petitioner Rangadhara Paikrai was temporarily appointed as PET. This resolution would suggest so, isn't it?
Yes, madam.
But he was actually, if this man was appointed in 1987 in a temporary capacity, why was he appointed? Because
in anticipation of a vacancy, because of sending him for training.
ठीक है, किंतु से ट्रेनिंग को गले 1989 रे.
Yes, my lord. He went. But my lord, what happened? He had appeared the interview. It is a local college. He had appeared the interview with him, and he stood second. And he, because in order to, there was a hue and a cry situation there. So in order to allow him to do something, because post 3 is going to open. So in anticipation of getting a post there, if you will continue there, there will be difficulties.
How? Till 1989, you had not been deputed to training.
No.
So how could he be engaged in 1987?
My lords, they have said in anticipation of any vacancy, but not that immediately after he gets the appointment. If he come and join there.
Let us see the other papers. Yes. Then that is why here the other documents are relevant, become very relevant.
Yes. Sri Ramchandra.
देखो रामकृष्ण महाकूट हेले आपण.
My lord.
You are Ramakrishna Mahakudu.
My lord.
You have given some documents. This Rangadhara Paikrai has also received 225 rupees on a particular month. Anyway, so your appointment was also approved. Now those documents which show his name in the renewal recognition form and his deputation to examination duty.
My lords, those documents are not in existence.
Not in existence. All right.
Yes. But if that is why as my honorable say, no further time, because I have said that come and file an affidavit here, because I cannot take the risk. That is why I sent for that. They may come.
I will record your submission. I will record your submission that these documents are not available.
Yes, not available.
Yes, I will record your submission. Yes, Mr. Patel.
There are another 2 pages.
Sir, excellent.
Then he joined, he got the salary from the date of joining. Did my lord get that?
Yes, yes, reaching the extra.
And my lord, another thing, next page, my lords. Ramakrishna Mahaprabhu 21-22, serial number 21, my lords.
So what is the duration of your training?
My lord,
you must have been relieved on a particular date.
My lord.
What is the duration of your training?
9 months.
9 months. Sir, kebe apna relieve hele, kebe phone join kale, se some jinsa document kai.
I'll give it to my lords because
see document oda darkar na.
Yes, I'll give it. I'll give it. My lord, what I want to show, serial number 21, Ramakrishna Mahaprabhu PT.
No, I've seen it.
My lord, he has taken salary 325 rupees and he has put his signature, Ramakrishna Mahaprabhu. Next, my lord, Rangadhar Paikirai 22, 225, he has not put his signature. In the entire, I have got the entire file from the date of appointment, he has not signed anywhere else.
Okay.
Only stamp is there, but not his signature is not there.
Yes.
So what he claims that he has been appointed by lawfully and he was continuing there is not correct at all.
He will give a reply.
My lord, sir.
Anything else? Or I will ask the state government to.
He says, my lords, he was appointed, my opinion number 6 myself, appointed on 13th 10/86. He says he has been appointed on 1/1/87. He joined on 5/1/87. And when he was not permitted in 94, 11 to 94, moved to DPI by filing an appeal. 94, my lords. Only my prayer, my lord, if the fact is that he has been permitted to join and he has done the work and his service was terminated, then he should have gone immediately thereafter, but he did not go there. But the fact is that, my lords, everything has been done for the reasons understandable but not expressible. Because the local people, everything is there. So there is no other way than to hear him and not to hear him opinion 6 also. My lords, I have filed a counter and my lords will kindly see. Page 94 of my counter, I think. Did I not get it?
Yes.
Page 94.
Yes.
My lord, 3970 serial number, Ramakrishna Mahaprabhu, physical education teacher, first. And it has been prepared by the government. Next page, my lords. After examining the relevant documents, the above employees have been found eligible for consideration of a block grant under GI Order 2009. Objection, if any, to the above list with the valid ground or supporting documents is invited within a period of 7 days. So, after my appointment, after my continuance, aid was granted and my case was considered and I have been paid. I have been paid my salary. Thereafter, but he is not affected by this way. My next page, my notes, there is a certificate that I have submitted from 1990. I completed it and I have submitted my certificate. Thereafter, my notes, I approached the Hon'Ble High Court and there the case was disposed of. Did I not get it? Page 99, my lords. The state government is directed to examine the eligibility of the petitioner for getting the benefit under the grant in aid of 1994 and release the grant in aid in his favor in accordance with the aforesaid rules. The differential salary as well as the arrear, if any, shall also be paid to him. The entire exercise shall be completed within a period of 4 months. 4 months from the date of communication of this order. My lord, after this order, he has given salary. Next, my lord, next page. Prior concurrence of government for issue of approval order of the post to the post of non-government aided college for receiving granting aid with effect of 1694. And I have been given Ramakrishna Mahaprabhu, PT, first post with effect of 1/3, 1694. thereafter 94, 96, 93, two-third and full salary. I have got it. No objection in any manner. Thereafter, my lords, in next minutes, in pursuant to the order number this that the High Court of Orissa passed, then they have given it to him the salary as it required as per the law. But prior to this, my lord, he has been also, this is the last order, A/6, page 104, he has been given the broad grant with effect of 1/2/2009. So, my lord, so what I pray and submit with all respect and courtesy, that where I have committed the mistake, my lords, authority are going on deciding the cases, whether I am entitled to get 2008 under 2008 and 6/1/1994 or not, and they have satisfied, they have given it. No complaint, no objection. And when I am going to, he has already retired. And when I am going to retire after 1 or 2 months, now they say that he has, I have not been appointed, but he has been appointed. So, under the circumstances, I pray, my lords, the order passed by the director passed the first order and held that he is the, he holds the first post. But when I approached the Honorable High Court, and the Honorable High Court quashed it and the directive for re-hearing, and the director heard it and passed that yes, this Ramakrishna Mahakur is the only fitting person and is the only person who has been appointed, who holds the first post. And prior to thereafter, my lords, I have been running for the last 32 years from DPI office, High Court to DPI office, all this way. And my life is spent with the only cases. Yes, displaced to that. Mr. Patnaik.
My submission will be only confined to the impugned order passed by the director, my lord. So, as it has been placed before lordship, previously a decision was taken by the director in the year 1995, where 2 sets of writ petitions were filed. One is with respect to implementation, one is with respect to challenging the same. So, there was a direction setting aside that particular decision of 1995 to rehear it. So, to comply that particular order of the Honorable Court, this decision has been taken after giving due opportunity to all the parties to make their submission in oral, my lord, and thereafter to written note of submission along with all documents, whatever they wanted to place the documents, my lord. These things have been taken into consideration, and because it is purely a factual aspect, my lord, and taking into consideration the different documents, my lord, a conclusion has been derived. So, with respect to the decision-making process, my lord, I can say that, my lord, there is absolutely no illegality. Now, when there is no illegality in the decision-making process, now coming to the evidence part and the documents which have been relied upon by the respective parties, whether it has been taken into consideration by the concerned authority or not. What I found, my lord, that has been discussed. And after discussing the things, the director has given his view, saying that, my lord, the petitioner in this case, Mr. Paikre, and actually his appointment order not seems to be genuine. The appointment order relied upon by him, it doesn't contain any number even. It is only dated one without any number. But simultaneously, fact remains, my lord, the resolutions and other things that shows that there was an appointment. But if the date of resolution and the date of engagement will be taken into consideration, these are contradictory to each other. The date of resolution, what
you were referring to some the original file, some documents.
File, my lord.
Yes, some documents. I asked Mr. Koro to look into it.
My lord, these present set of documents, what it has been present to me, everything is available in that.
And any other document which he was referring to, that he was his name found place in the renewal recognition form and that he was also deputed for execution.
He had taken his written note of submission, that has been also taken into consideration.
Whether he was sent off for the examination duty and all that.
My lord, one thing what I found, my lord, in fact, he had mentioned all these points. But additionally, my lord, at minimum 2 to 3 times, my lord, he has also made a request before the petitioner in this case, before the director, my lord, to call for the previous record of 1995. But that has not been dealt with. In this appeal file, my lord, what I found that because on argument basis, my lord, I can say that since the decision taken by the competent authority, that director, my lord.
No, the fact is, when such a plea has been taken,
yes,
it is for the court to examine it.
Yes. No, my submission, my lord, that 1995 decision, the file in which that particular decision has been taken, since that particular decision itself has been set aside by this honorable court. So a re-hearing has been made, and whatever the documents were placed before the competent authority by respective parties, that has been taken into consideration, and following due procedure of law, my lord, giving adequate opportunity to file the written note of submission, argument, everything, a conclusion.
No, but whether this particular aspect was taken into consideration or not, and now the managing committee says that we don't have any records.
But this is also the
So this is, as yes, Mr. Patnaik, with his vast experience, will understand. The court can take adverse inference. The court can draw adverse inference. If you don't produce the documents, then how will you know he's making a plea? Unless you come forward with a specific stand that there is no such document.
But on the contrary,
that his name was not there in the renewal recognition form, or that he was never deputed to examination duty. Unless you say that.
On the contrary, my lord, it is the stand of the petitioner as the appellant in the before the appellate authority and in his written note of submission that the records are destroyed and whatever it is available, those are all manipulated records. I think that is the stand I can also take a lordship to those particular points. But the records have been destroyed.
No,
and the records have been prepared to just favor that Mahakut, Shri Mahakut. That is what it has been mentioned.
Because as I had proposed a question to Mr. Patnaik, there is an apparent gap. In 87, the managing committee allows him to go for training. He doesn't go till 1989. And in between, this man has been appointed. How?
Yes.
How?
He did not go for 89. 1 after that, he has gone, but they have given 4 years time to him.
All right. That
in anticipation of the situation, something may happen, the difficulties, that is why they gave appointment to him.
How? There is only one post. How can they give appointment to another person in that?
So they called the interview, he appeared the interview, and in the interview he stood second. So in anticipation of a future vacancy, they have given the appointment, my lords. And
is it possible? Unless the vacancy actually accrues, how can somebody appoint?
The vacancy accrues because of taking study leave.
That is why I am asking you, when did you take study leave? When exactly did you take study leave? You must have been relieved from your duties.
Yes.
So when was that?
Yes, I can give it. My lord, sir, only I will do to one thing. My lord, see, I will page 15. 15 to 20. Salary has been paid. And his name is there, serial number 21, 22. Right side, my sizes. Serial number 21, 22. Ramkrishna Mahakur and Gangadhar Paikrai.
So how can both be appointed as
one post? No, my lord, you can see the right side, the stamp is there, but his signature is not there.
All right.
So next one,
but he may not have drawn that money. But a revenue stamp has been affixed, his name has been written, PET at the rate of 225. Total है 450 टका. It is R.K. Mahakur at the PT at the rate of 225. R.K. Mahakur sign कले ये sign कले नहीं. किंतु ये ऑप्शन दिवल तो सिद्धवेना का नाटा लिखा ना.
During that period he was there and they have written it.
On the next page also the same.
That continued, my lord, if your lordship would go for the record of the state, that continued, my lord, from 89 onwards. It was only after 1990 when they prevented me from doing it. that my name doesn't find place in the register.
November 1999.
Again. And your lordship would appreciate according to the resolution, he is Lord relieved from duty on 1st of August 1990. The certificate says he has joined my lord in June or July. That is there in the state government's files. So if he is relieved from his college with effect from 1st of August, which your lordship have read, my learned friend has also read in that resolution. Lord, I'm asking this question to myself, Lord, how can he join the college in June? Your lordship would see that particular.
You can do one thing.
Page 90.
Give the file.
Yes.
You give the file. We'll keep it part to next week. I'll go through the file.
Yes, ma'am.
And these documents also.
Yes.
Are for the arguments and part.
I'd only request the lordship to go through those payment register because it begins from page.
No, I will go through the. Sri B.K. Patnaik, learned counsel for the opposite party number 5 and 6 submits that despite best efforts, the documents / records relevant records / documents have not been able to be traced out. He produces Xerox copies of some other documents such as the resolutions, attendance sheets, etc. Same be kept on record. Learned State Council is ready with the original file.
Cover
key file
in fact, they have stated that it is as if it is a compliance file to the order of Honorable Court.
Yeah, but what is it actually?
663.
It's an appeal file though.
Appeal file.
The file the files the original case record.
Yes.
In the appeal before the director.
Yes.
Same be also kept on record. Okay. Is this matter? No. 16th July. I'll be, I mean, it will be useful if you can prepare a index.
That I only pray, my lord, the lordship would kindly go through the teacher's attendance register. Well, he says that he is appointed with effect from 15th. He keeps on signing it from the 3rd.
There's some discrepancy somewhere.
And
but
my lord, my learned senior my lord, he has placed the opposite party number 6 counter. So far as the college is concerned, my lord, he says that I have misutilized their kindness to me. That is the language which they've.
I will go through.
The counter filed by the college authority.
The thing is that his appointment has been approved and he has been brought under the granting aid for.
Again.
That is
my lord has been made subject. My lord, your lordship would appreciate this particular case was the first case in 2009. That's why in the miss case, they have lordships have said that any payment to be made will be subject to the result. My learned friend, my lord, he files another petition 8944 of 2011, where he knows that he is a party to this case. He had already appeared. And my serious doubt, my lord, whether he has declared this particular writ petition to be pending or not, if the other writ petition is not there. He takes my lord, the order that his granted aid may be paid. Accordingly, his granted aid is paid. But previous to that, my lord, if the lordship would kindly produce the order dated, my lord, 10th of January 2011, in this case number 16167 of 2009. Now they say that any payment made should be subject to the writ petition. That order is there now.
So we'll see on that day. Let me go through the file.
And my lord, your lordship would appreciate one your lord, since your lordship. Okay? Lord, so the director, my lord, he says, at the time of appointment, my lord, I was the only qualified PET continuing in the college. Because in 87, he did not, admittedly, he was not a trained CPA, my lords. He attained that qualification in the year 1990. But right from the date I was appointed, my lord, I was having a CPA qualification.
Let us see.
So, my lord, sir, I have given teacher's attendance register where his name is not there. Only my name is there.
Okay.
Yes, sir.
Yes.
All right,
next matter.
My lord, sir, Shall I give it this file or to? allow with other side?
File, let it be in the record. Let it be on record.
Xerox कर दे दी थी.
Xerox कर
दे.
Sir, I've got the information by learned senior Anantu when they received the grant in it. Because if they have received it in 89, this gentleman, my lord, he did not have his training. So his name could not have been sent to the CHSC or whatever body, my lords. So let that information at least, even if the records are not there, my learned senior, my lord, can say that the date on which they have got their grant in it or their affiliation.
That order is there. Grant in order is there on record.
No, that is so far as Mahakut is concerned. I'm, Lord, humbly submitting, Lord, that the date on which their college was recognized and it received, came into the grant in it full.
All right.
Well, that would be crucial. At least that date can be given. And there
that you can, you can inform.
Everything I shall give him. Whatever he said, I shall give him. Nothing I will keep it. For the ends of justice, date of a permission, date of a recognition, date of a grant in aid.
Sri B.K. Patnaik, Learned Counsel for the Sri B.K. Patnaik is further directed to produce, to furnish the date on which the college came into the granted aid fold.
Yes, I agree.
Yes.
TC Lordship would see who was having the trained qualification at it. Oblations.
Item not 20.
Maybe treated as part of the.
It is part of, I have said.
Right.
What further rules in part will Yes, item 20.
Transfer application.
Yes. कौन थी ना मेरा खाली थी नहीं कौन नीचे ऑर्डर अच्छा also there is no appearance, we'll take it up. Sri B.P. Pradhan, counsel for the petitioner is present. None appears for the opposite party on repeated calls. Yesterday also there was no appearance from the side of opposite party. It is the as such it is presumed that he is not interested to represent the. As such, it is presumed that he is not interested to defend this case. The transfer application is therefore taken up for hearing. Yes. The transfer application being of the year 2019 is therefore taken up for hearing. Yes. What do you want? Transfer from which place to which place?
The wife is the petitioner.
From Nayagarh to Bhubaneswar.
Nayagarh to Bhubaneswar.
On what ground?
Husband has filed the divorce application.
Yes, on what ground?
Earlier occasion also, same situation was there. Husband had filed a divorce application in the court of the Learned Judge Family Court, Nayagarh. I approached this honorable court. During pendency of my transfer application, he withdrew the divorce application. My TRP application became infructuous. Now, after withdrawal of TRPC, now another divorce application has been filed. I have taken a specific ground in the present transfer application. I am staying at Bhubaneswar. And number 2, 3 proceedings, criminal proceedings pending at Bhubaneswar.
Correct.
That I have given para 12.
Correct. Therefore, transfer has been made. Therefore, transfer has been made on the ground that the petitioner is residing at Bhubaneswar, and further 3 other proceedings are pending before different courts at Bhubaneswar. Stop. 3 other proceedings between the parties are pending at before different courts at Bhubaneswar. Allow करते हो? हाँ? Allowed.
Item 21.
The remaining order will follow.
My lord, transfer petition. The petitioner 3 times, 3rd times issue files requisites, but the copy is not turn up and
You will serve it through police. Just give another copy to the state council, so we will serve it through police. Notice is sufficient. Jahan legote he janta tha na hole other role kim dispose of koi.
Kotakra diviri appear
That everybody knows upon. Let an extra copy of the transfer application be served upon state council, who shall cause the same to be served upon the opposite party through the IAC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
24th July.
On 24th July. Let this matter on 24th July. आइए हाँ आइए तो ठीक है further proceedings in CP number 165 of 2023 आगुर stay है ना थला
खाली कोनो
order no ଗୋଟେ ହେଇଥିଲା ଗୋଟେ particular date ରେ ଯେ ସେ କିଛି order ହବନି ବୋଲି expect
Further proceedings in CP number 165 of 2023 pending in the Court of Learned Judge Family Court Jagatsinghpur shall remain stayed till the next date.
Item 22
Lordship, petitioner in this case is transfer petition from more court to court in
Yes.
Navranpur.
You want this to be transferred? This criminal case.
Lordship,
You are the accused person.
265 of 23.
You are the accused persons.
Lordship.
Yes. Why do you want transfer?
Lordship, as per direction of this honorable court, when petitioner go and bail, release on bail, surrender before Umar court, the opposite party number 2 along with the others member asserted.
So what happened to that case? Already charge sheet has been filed on 34/24 under section 341, 294, 323, 506 against the opposite party and family members. Lordship. So we will transfer it. What do you say? 379 has been struck down. 506 is there, my lord. 506 is non ଅଛି ଗୋଟେ 323, 294, 323 ଅଛି ଆଉ କଣ? So assault part prima facie correct, my lord, isn't it? Then I will direct transfer. Yes. The accused persons ମାନଙ୍କୁ ସେଠି ମାନେ if they are not, if they have been assaulted, nobody. Number 2 is the lady, so will face difficult. Open number 2 कौन? She is the informant. She is the informant in that case. So thoroughly they were released on bail.
Again,
Open number 2. She is the informant in the case in which they were released on bail. Oh, yes. The petitioners. Yes.
Again, court order is that also surrender kale. I was personally present there. Lordship, near 200 person. And 200 ଭଳି ଲୋକ ଆସିକିନା ଆଜ୍ଞା କୋର୍ଟ ରୁ ଯେତେବେଳେ ସରେଣ୍ଡର ହେଇକି ବେଲ୍ ଅର୍ଡର ହେଇକି କୋର୍ଟ ବାହାରକୁ ଗଲେ 200 ଭଳିଆ ଲୋକ ଆସି ଆଜ୍ଞା ତାଙ୍କୁ ଆସଲ୍ଟ କଲେ ତାଙ୍କର ଯୋଉ ଗାଡି।
Where is that FIR? Where is that FIR? Is 21. पूरा देना है। এটা রোটেট করে না কিন্তু হবে মেহরবানি করে লাগছে এগুলো চলো You have the records? And record is not there. I have taken the case in which charge sheet has been submitted, which you are saying, you have the charge sheet? No, man. No, you produce the charge sheet. I'll see the charge sheet and then I'll transfer it. Yes, madam, because 3 are ladies. And maybe. State Council submits that the the charge sheet has been submitted in the case instituted on the basis of FIR lodged by the petitioners against opposite party number 2 and her family members. Yeah, sir?
Yes.
This court would like to peruse the FIR as well as the charge sheet in the said case. The state council shall produce the same. Let's this matter next week.
Item 23.
Because I may have to refer to the charge sheet in my order. That is why.
Charge sheet date is there. Date is.
नहीं charge sheet अपने देखिए अपना ही चीज़ से मैंने
Item 23, my lord. The matter was
23.
sent to mediation center, my lord.
What happened?
Report is there, my lord.
बिल्कुल ये ला.
By
No, he is your.
no,
Settled.
the party agreed to reside separately, my lord. And also the opposite party husband will pay rupees 20 lakhs as permanent alimony.
So ଆଉ transfer କାହିଁ କରିବା?
Out transfer.
Transfer ଦରକାର ନାହିଁ settlement ହେଇଗଲାଣି so ଆପଣ ସେଇ କୋର୍ଟରେ transfer ପରେ mediation ରେ ତାଙ୍କ ଆପଣଙ୍କୁ joint petition ଦେବେ ଆଉ କଣ?
File
joint petition ସେଠି file କରିବେ ଆଉ.
file କରିବୁ.
Yes.
Instead of let's say kind second year 20 lakhs will be filed in shape of demand towards permanent alimony to the
In 5 equal installments.
no, it will file at a time, my lord.
ଏ ଯା ସେଟା ଯଦି ତାକୁ ଇଏ କରିବେ ସେଟାକୁ ଆପଣ joint petition ରେ କରିକି
Yes.
mediation ରେ ଆପଣଙ୍କ settlement ହେଇଗଲା. That you will to file it before the court will and the court will pass necessary orders.
And other proceeding, my lord, will be dropped, my lord. Consequent to other cases. My lord.
That order cannot be passed by this court. The transfer can be passed. Other criminal proceeding to drop the will
The other 492 and other.
482 more possible. Consider. The report of the mediator dated 19/6/2024 shows that the dispute between the parties has been amicably resolved as per terms and conditions indicated therein. Stop. Since the parties have already resolved the dispute, there is no necessity of transferring the case as prayed for. The transfer application is therefore disposed of, directing both parties to approach the court below by filing appropriate application for disposal of the case in terms of the compromise. That's all.
Item 24.
ସେଇଠି ଆପଣ ଯୋଉଟା modify କରିବାକୁ ଚାହୁଁଛନ୍ତି ସେଇଥିରେ ଆଉ ଥରେ ଭର୍ତ୍ତି କରିଦେବେ ଆପଣ ସେ ମିଡିଏଟର ରିପୋର୍ଟ ଆପଣ ବାଇଣ୍ଡିଂ ତ ନୁହେଁ ନା yes ତ ଗୋଟେ ତ ସକ୍ସେସଫୁଲ ହେଲା ନା ଗୋଟେ ନା ଆଉ ଦୁଇଟା ବି ହେଇଛି ଆଗରୁ
I'm for the petitioner.
I am for the opposite party. Marriage was held in the year of 2022, man.
yes
Send the record to the mediation center.
yes what do you say agreeable
Some financial arrangement, a poor lady has no income to
where are you residing
ask.
Aska where are you residing
In Canarapada.
Hmm?
Canarapada.
let the mediation take place at Barampur you can go to Barampur even Aska ରେ ବି ହେଇପାରିବ
ଏଇଠି ହଉ ଗୋଟେ ଚାନ୍ସ
ଆପଣ ପଇସା ଦିଅନ୍ତୁ ତାଙ୍କୁ ଯିବା ଆସିବା କରିବା ପାଇଁ ସେ ଆସ୍କାରେ ଆସିବେ ବସ୍ ଭଡ଼ାଟା ଦିଅନ୍ତୁ in course of hearing both counsel for the parties suggest that the matter may be referred to mediation. Stop. Learned counsel for the petitioner submits that his client, being a lady, is a resident of Aska and has no means to pay for her travel to Cuttack. On a query by this court, learned counsel for the opposite party husband agrees to bear the traveling cost of the petitioner on the dates of mediation. Let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties shall act upon notice received from mediator notice issued by the mediator, correct? And render full cooperation in the mediation proceeding.
Amount may be fixed.
Eh? Further,
Not the travel.
opposite party husband shall pay the actual traveling expenses to the petitioner on submission of proof. Yes. Submission of proof submission of proof is this matter on 14th August.
25. In this matter, wise they have taken time. That I had proposed Kendujhar will be the suitable place for both parties. If the matter is transferred from Rairangpur, she has spread because she is the employee of a bank. She is serving at Boningard. I am a junior engineer under the state government as a Karanjia. I had filed 13 petition before the Rairangpur subject. Now she has prayed for her. That score he had taken, said they had taken time.
Lordship, the pray for sought adjournment, Lordship.
Why?
Communication heiparlani. Our petitioner is not in Odisha.
All right. As prayed for by learned counsel for the petitioner, list this matter next week. Next week, next Thursday, next Wednesday.
Obliged.
56.
Opposite party today. Lordship may ran some time. My lord. Arjun, in the meantime, I will take Mr.
I said, can it be settled?
No.
Cannot be settled.
Petition opposite present opposition filed a restitution petition before family court judge.
The restitution file goes in the money, you want your wife back.
Yes.
So why not settle it?
Yes.
Yes, what do you say? If you agree, I can settle to mediation right now.
Yes.
We are agreeable. Yes, what do you say? Sri UK Lanka advocate and associates have entered appearance for the opposite party. The filing Wakalatnama. Same be kept on record. Their names will be reflected in the cause list. In course of hearing, it is submitted that the dispute between the parties can be settled through mediation. In such view of the matter, let the records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. List this matter on 24th July, August. 14th August.
Interim order.
Interim order to continue.
Item 27.
We have no objection.
You have no objection if the case is transferred? Yes. Who did transfer?
Jaipur.
Nabarangpur?
Jaipur.
Nabarangpur, Jaipur. Yeah, 44 kilometers.
60 kilometers.
44 kilometers.
Yeah, 2 minor children is there.
Na 2 minor children will go. Bodhijiva na ko?
Na ta sangare rochonta they are.
Again, 44 kilometers mu kuncha pa minor children mu ta 60 kilometers ko leni. Koraput jihar pratek 22 kilometers ko tota thana. Pratek 22 kilometers ko tota thana. So everything you will find in that even number division.
Jani lekin semane kujante 60 kilometers.
60 se bhul question. Exactly 44 kilometers. Jaipur Koraput 22 kilometers. Setu Simligura 22 kilometers. Em so tankara se seven settle କରିଥିଲେ ମାନେ ଥାନା ଗୋଟେ ଗୋଟେ କରିବା ପାଇଁ ଥାନା ଆଉଟପୋଷ୍ଟ whatever. ଏବେ ଆଉ ସେଟା relevant ନାହିଁ but anyway the petitioner wife seeks transfer of CP number 6 eta 6 of 2024 pending with the court of learned judge family court Nabarangpur to the court of learned judge family court Jaipur. Therefore, transfer has been made on the ground that the petitioner is a resident of Jaipur and has 2 minor children. As such, it would be inconvenient and difficult on her part to travel to Nabarangpur to attend to the to attend the court on the dates fixed in the case. Stop. Learned counsel for the opposite party submits on instructions that his client has no objection if the case is transferred from Nabarangpur to Jaipur. Huh?
Number 28.
Yes.
For interim bail, your lordship. And as for direction, he was in, the petitioner was in, interim bail, and he was in, as per direction of your lordship, he was surrendered on 3rd May. And during that, when he was in jail custody, taro condition ete serious है, jail doctor refer कले SCB medical. Due to non-availability of that custody party, ताको 3 दिन पर SCB को निया है ना. Say SCB रे थिला. Let them take instruction. Now he is in Puri jail.
Lordship, Mishra Babuji, कितने थोड़ा अपन interim bail case में
First allowed for 6 weeks.
Last time अपन खइले
Then interim bail extended for 6 weeks. Then extended for 10 days. Again allowed for 6 weeks. 4 time allowed. 3 थोड़ा 6 week लिखा.
ये बड़ा एक केस ऑर्डर पास कर मोर भी मौका ही जुआ.
Let them
This has become a mockery of justice.
No, you
rather regular bail कर दो. Regular bail कर दो. नॉले ये अपन सबोले इम्ति जुदी पिटिशन गोटे पकेबे
5 मास रहिलेनी 6 week 10 दिन.
एक केस रे को अक्यूज भी जाई छंदी.
ये काहे ये ब्राउन शुगर की
ये चलो
356 ग्राम.
केते केजी
356
रहउची.
आउटसाइडर जे पांडे से जाई छी बेले.
जाई कोन कोन ये तार कोर्ट की स्टेटमेंट हितो की कोन हितो ना रिलीज कर देबी अरे रिलीज कर दे माने मो कोर्ट रिलीज कर देबी
नहीं
मो बेंच रिलीज कर दे ना बेंच को ना जे तो कोर्ट की स्टेटमेंट देखे नहीं जीवे.
Condition is actually condition is serious. Let them take instruction. जहाँ कोर्ट करियो म किछ करियो.
सीटा तो निश्चय जहाँ कोर्ट करियो कोन किछ करियो जी जे करियो बोले आपण भाबुचंती. Anyway, take instruction. It is submitted that the petitioner, who is presently lodged in Puri jail, is suffering from severe ailment.
Diabetic, pancreas infection, kidney infection, and facial paralysis.
A host of ailments. His condition is serious and he requires treatment. Learned State Council shall obtain instructions in this regard. List this matter on
Friday.
10 July. Next week.
Okay.
Yes.
29.
For modification of order की vocation की ना थी. Upon you have appeared, J. Sahu and S.K. Patnaik appeared for the petitioner. Bhagirathi Das and Papuli Das.
Yes, extension of time.
ମୁଁ ଭାବିଲି ଆପଣଙ୍କୁ ବୋଧେ ଦରକାର ନାହିଁ.
नहीं से पूरा नाट आसीन तो तेन को छाड़ दी.
This is the first time.
Yes.
All right, 2 weeks time.
Item 30.
Already, this is my second round of journey before your lordship.
Yes.
I have been arrested on 6/9/2021 under section 20B, Roman 2C, 25 and 29 of the NDPS Act. Initially, when my bail was turned down by your lordship, Annexure 4, page 38, your lordship had directed expeditious trial on 14/8/23. At flag Z, the report has come from the learned court below.
6 out of 19 witnesses have been examined.
Yes, I am in custody since, my lord, 6/9/2021.
Only problem.
That problem, your lordship grants 3 months.
कौन करे
ଆପଣ ଦେଇଛନ୍ତି ଜଣକୁ 3 ମାସ
ଦେଇଛି ଜାନା ତାର ସ୍ପେଶାଲ ଟିମ୍ କରାଗଲା ତାକୁ
ନାଇଁ 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 ଇଏ ମାନେ ଅପ୍ରିଲ ରେ ମେ ରେ ଯାଇଛି ରିଲିଜ ହେଇ
ଇଏ
ନାଇଁ ନାଇଁ ଯୋଉ ଯାହାକୁ ଦେଲେ
ଏଇ କେସ୍ ରେ
ହଁ ଏଇ କେସରେ ଆପଣ ଦେଇଛନ୍ତି ବେଲ
ଦେଖେ
ଆଜ୍ଞା ସେ ଆପଣ ବେଲ ଦେଲେ ଆପଣ ବେଲ ଦେଲେ ହଁ 4/1/24 ଦେଲେ ସିଏ 4 ମାସ
she being a lady
correct but she was also an outsider
3 months but is she appealed
ମାନେ ତା 3 ମାସ ସରିନି ସେ ଗଲା ମେ ମାସରେ
because the case has been split up for abscondence of one Sanjeev Bira.
ହଁ that he is a local man but
He has defaulted.
This lady has gone in May. That time is not over as yet.
All right. The court below, Learned Additional District and Sessions Judge, Parla Committee, has submitted a report stating therein that the case record has been split up as because of non-appearance of accused Sanjeev Bira, who defaulted in appearance, who did not surrender after expiry of the period of his interim bail. In the trial, in respect of the petitioner, 6 out of 19 charge sheet witnesses have been examined. How far how
Sir, Ravi Prakash judgment ଆପଣ ଜାଣିଛନ୍ତି ସେ କହୁଛନ୍ତି 3 ବର୍ଷ ରହିଲାଣି and out of 19 my lord only 6 have been examined from 2021 and I'm in custody since 2021.
Now if I release the bail, release you on bail, now this case will also be stalled. He will never come back.
Her term is not over.
That I know.
Is not over.
That is why let us wait. କେବେ ସରିବ ତାଙ୍କର?
ତାର ଜୁଲାଇ ଅଗଷ୍ଟ 2nd week ରେ ସରିବ।
ତାପରେ ନବା ଦେଖିଆ whether she is appearing or not.
ଆକୁ ବି 3 ମାସ ଦେଇଥାନ୍ତୁ।
ଇଏ ଗଲା ମାନେ ଟ୍ରାଏଲ ଟା ବନ୍ଦ ହେଇଯିବ।
ଆଜ୍ଞା ଲୋକାଲ ଲୋକକୁ ସେ ଧରି ପାରୁନାହାନ୍ତି ମୁଁ ତ ବାହାର ଲୋକ ଠିକ ଅଛି ମୋର ବାହାର ପାଇଁ ଆପଣ ରେଷ୍ଟ୍ରିକ୍ସନ କରିଛନ୍ତି ଆଇ ଏଗ୍ରି ଟୁ ଇଟ୍ ମାନେ ଆଇ ଡୋଣ୍ଟ ଡିସ୍ପ୍ୟୁଟ କିନ୍ତୁ ଲୋକାଲ ଗଜପତି ଲୋକକୁ ସେ ପୋଲିସ ବାଲା ଧରି ପାରୁନାହାନ୍ତି ମାନେ ଦେयर ଇଜ ଅ ଟାସିଟ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ବାହାର ଲୋକ କାହିଁକି ଦଣ୍ଡ ପାଇବ ଲୋକାଲ ଲୋକ
ହବନି one consistent stand is being taken out. See, because she's a lady and she was in custody for 2 years.
Well, Lordship, may kindly see page 9 for a moment. Kindly see page 9. This Sanjeev Bira is a local man. And others are not local. Others are not local. If he would have been outsider, my lord, at whatever your lordship is saying, maybe, my lord, he may not comply with lordship's direction. But here local person has done and for that I am suffering. And your lordship has seen the report out of 19 only 6 they could examine within being in custody my lord they could only examine 6 witnesses and those are all are official witness not that they are any private person. All official they are not turning up. My lord I am in custody since 21. Lordship may consider that as
no, I'm willing to consider, but the fact is, once I release him, and from the general trend, what will happen is if he doesn't come back, this trial will also remain stalled.
But at least, my lord, I should know my liberty should not be sabotaged due to the action of the local police.
Well, why? Supposing, no, I am anticipating why bail. What is the purpose of the bail? Bail would be that he would appear.
Yes.
To face the trial.
Yes.
If that basic thing is doubtful, so how can the court grant you bail? Once I release you, and since you belong not to Orissa but outside, and there's every chance that he will not come back.
Here the people of the same police station is not appearing.
This is just an exception. This is an exception.
But for that only, my lord, the case was split up because he is not come. And your lordship may see that the latest view of the Honorable Apex Court is that I should not be allowed if the trial has a snail speed. And this trial, in fact, is on the snail speed.
No.
I leave it to your lordship. My lord, I've placed all my cards before your lordship.
Yes, release this matter
Your lordship may
One
impose
week
cash security, anything.
Cash security, nothing. These are moneyed people. They will throw 5 lakhs and go away. And the poor judicial officer will have to face the music by submitting explanation. Why are you not disposing of the case, my lord? And in every senior officers meeting, we'll give a list of pending warrants to the collector and the SP. आया करो ना सर हम कर दो किसी और the entire thing will come to a standstill. What is happening at the ground level must also be considered by the court.
Absolutely.
It's not that I'm biased or in any absolutely not.
I'm the last person to say that. But no, your argument is valid.
Your argument is valid. But what I'm saying is let us wait for that other person. Let it remain in limbo. Let us see. And for everybody, I'm passing the same order.
I'm now standing in the gallows, waiting for my turn to be hanged. And due to their latches, prosecution latches, I would say. My lord, I'm standing in the gallows.
Why? Your case has been split up. Your trial is going on. The sooner your trial gets over.
Your lordship has also seen the speed. Out of 19, they could examine only 6. It is their officer. It is not my officer or my witness or any independent witness there.
I know it tells upon the system, but it's very difficult. NDPS cases, they don't progress as quickly as other cases. They're very difficult.
All official witnesses.
Yes, even the official witnesses. They independent witnesses examination time lagi କିନ୍ତୁ ଏଇ ମାନେ ଯୋଉମାନେ କରିଛନ୍ତି search and seizure of the thing contraband and so many formalities are there in the NDPS Act. Recording delivery. Anyway, let's just matter 1 week after. We'll see.
Item 31. Item 29. The informant is the injured. They have not produced the injury report. That part may be deleted. Last line, para 5 ro.
ଆପଣ extension ମାଗିଲେ ତାକୁ delete କେମିତି କରିବେ ଆପଣ?
ସେଟା modification ମାଗିଛି ମୁଁ.
କୋଉଠି
modification of order. With extension.
All right. ଆଗ ଲେଖି ଦିଅନ୍ତୁ.
Para 5.
Last line of paragraph 5 be deleted. Hello. But that 2 weeks time.
Oh, please.
Item 31.
May please, your lordship. My petition initiated custody my lord 24/2/2022 my lord. And offense on decision my lord 20B2C of NDPS Act my lord. And the possession of petition my lord 102.5 kgs of ganja recovered from the truck, the petitioner along with another my lord. And your lordship.
No, trial is at a fag end.
Yes, my lord.
3 witnesses have been examined.
Yes, my lord. Lordship, this is the last order for the co-accused. Co-accused entered 3 months time interim bail. The last witness was examined 1 year back, my lord.
Okay. Yes, ma'am. 3 months, madam.
Item 32.
May I please your lordship? I am in BSc Miller. In item number 32 Miller.
Yes.
Your lordship, in item number 32, I am praying that BLAPL number 4941 for 2022 may be tagged and come up with this application Miller.
All right. As per for this matter next week along with BLAPL number
4941
of
2022 Miller.
2022.
Congratulations.
Item 33.
May I please? Petitioner is in custody, my lord. 13/2/2021. No, earlier notice was issued to, since SC/ST Act is there, notice was issued.
Somebody is appearing. 33. And informant to mother. And victim. What is your name?
My name is Omyo Mahanti.
But you have already been granted bail.
The interim bail was granted.
9/11.
Thereafter, you was surrendered, my lord, and moved the court below and.
Yes, the victim has appeared. The informant.
Informant has appeared. Notice has already been served, Your Lordship, as per Your Lordship direction. And she is the mother of the victim. Informant.
Release before that.
Before that, yes, before that,
We'll say, let us say, on 20th.
20th.
Then state council has obtained instruction, written instruction. From the medical doctor, Dr. J. Monaigar, that the petitioner is in fact suffering from.
My lord, next page. Se hospital रे ताको डेट देइछन्ती सेठी सर्जरी हेई परिबो
In fact suffering from
Gallbladder stone.
gallbladder stone. And he is scheduled to undergo surgery on 22nd July. So. Considering this application except is for a tablet.
No, my lord.
No,
So
Yes.
this will be kept.
my lord, my lord.
Yes.
Considering the above facts. I mean, you can take again to. Let the petitioner be released on a given way. For a period of 4 weeks.
How ticket operation pare.
Quickly. So the ticket was released also on such terms and conditions. This office can operate from 20th July to
Item 35.
May plus. Annexure 4, page 20, my lord, kind of glance. The lordship granted bail to one of the accused. Petitioner is his brother, and against his the allegation is that accused Dr. Khan was using a mobile phone that is registered in name of the petitioner. That much only. Page 20, my lord, kind of glance.
What is the allegation against you?
Against me, the allegation that the Dr. Khan.
Yes, Mr. Mahathi.
Yes, but what he's saying that is correct.
মানে co-accused statement.
Basically, Barambar, I mean, notice the loop.
Use করছিলা।
He didn't come. Therefore, NBW was obtained from the unbook. It's a fact that the main accused who was using the mobile phone, that mobile phone belongs to this petitioner. Ma'am.
When are you, since when are you in custody?
15/6/2020.
The petitioner is in custody since 15/6/2020. आगे लिखी देबे
23rd
Sri Sujagata Dwivedi, Learned Counsel for the petitioner, and the Ganalok Mahathi. You are for the NCB. Learned Counsel appearing for the NCB. The petitioner is in custody since
15/6/2020.
15/6/2024 in connection with such and such case. The prosecution case is that a team of NCB apprehended a truck on the Mumbai-Kolkata highway.
Yeah, outside Rajasthan,
Wherein 280 kgs of contraband ganja was being transported. The petitioner was arrested long after, as he happens to be the owner of the mobile phone. Mobile phone used by
Dr. Khan.
He happens to be the owner of the
mobile number of Dr. Khan was registered in the name of the petitioner.
Registered owner as he happens to be the registered owner of the mobile phone used by the principal accused Akhtar Khan. Stop. There is no other allegation against him relating to the occurrence in such view of the matter, and taking note of the fact that said Akhtar Khan has also been released on bail, I am inclined to allow the prayer for bail. Let the petitioner be released.
Only one prayer, my lord. In the first title, the name of the opposite party I have typed as the state of Odisha. I am filing the consolidated court title. Seat file kori lordship mein indicate.
Learned Counsel for the petitioner. Correction koriye na?
Yesterday I was not appearing because of that. He has written state of Orissa.
No, so you have to correct it.
Of India.
No, I will file a consolidated court.
अरे sir, अपना correct कर ले तो consolidated file करिए. Learned Counsel for the petitioner is permitted to correct the error in the cause title and file a consolidated cause title in the counter.
Item 36.
No, sir. Item 36. Your lordship has recently rejected the bail application. Our main prayer is for interim application, my lords. Lordship says his mother is extremely ill. Annexure 3 at running page 16.
Very serious allegation.
Yes, my lords. He had shot my lords. Merit, I am not asking your lordship for bail. Only interim bail to.
Interim bail, have you filed any IA or your main prayer is?
Your main prayer is.
Interim bail.
So then he has to take instruction.
Instructions also notice, my lord, 3 SC is there.
Oh, 3 SC Act is there.
Notice
So you have to issue notice. You may take, you give a copy to him so that
Give copies to him.
let an extra copy of the bail application be served upon the State Council, who shall cause the same to be served upon the informant / victim through the IIC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on 31st July. केमती करिया 31st July अभी आगे करते 24th July करते 24th July. Further, the State Council shall also obtain instructions with regard to the amendments made in the bail application.
37.
On the magical documents also.
इसी जहाँ दी जिसे amendments तो करेंगे ये तो पूरा टाइम interim bail पे तो अपने ये
Yes, man.
No, sir, 37, I filed for extension time, my lord.
To surrender.
No, my lord. I'm not aware that. Because I am working as a labor, my lord, in outside. For that reason, I am not able to surrender myself, my lord.
All right. So 2 weeks time is granted. Hello. 2 weeks time.
This is the first
आया
time.
आया कौन कौन
Extension time, 2 weeks time, there I am surrender करी.
ମୁଁ 2 weeks କହିଲି ପରା.
I am not placing that.
No.
Sorry.
Item 38.
My lord, in earlier date, one system statement of Abhishek Pandey with the injured person was called for. But there is nothing statement in the record, my lord.
No. Statement is there, my lord. I have been one, but second application though not maintainable, lordship though directed. Statement is there, my lord. May I please, my lord? ଗତ 8-10-23 ଦିନ ରାତ୍ର ପ୍ରାୟ 11ଟା ହେବ ମୁଁ ପ୍ରମୋଦ ସିଂ ଅମିତ ମାଇକଟା ୟୁଜ କରନ୍ତୁ ତାଙ୍କ ମୁଁ ପ୍ରମୋଦ ସିଂ ଅମିତ ଝା ଓ ସୁରେଶ ଚୌଧୁରୀ ସମସ୍ତେ ଗ୍ରୁପ ଚୁପ ପଡାର ପଡିଆରେ ବସି କଥାବାର୍ତ୍ତା ହେଉଥିଲୁ। ଏହି ସମୟରେ ନବଦା ଛକର ଆଦର୍ଶ ଦୁବେ, ଗଙ୍ଗାନଗର, କାହ୍ନା ପରିଡ଼ା ଓ ଲମ୍ପିଟା ବାହାଲର ରଞ୍ଜିତ ରାୟ ଦ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଏକ ମୋଟରସାଇକେଲରେ ଆସି ମତେ ଜୀବନରୁ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଖଣ୍ଡା, ଭୁଜାଲି ଓ ପଥର ସାହାଯ୍ୟରେ ଆକ୍ରମଣ କଲେ, ଯାହା ଦ୍ୱାରା ମୋର ଡାହାଣ ହାତ ଚିରା ପ୍ରଚିରା କାଟି ହୋଇଛି। ମୋର ପିଠିରେ ମଧ୍ୟ ଏକ ଛୁରୀରେ ଭୁସି ଦେଇଛନ୍ତି।
ସ୍ପେସିଫିକ ଓଭର ସ୍ପେସିଫିକ ନାହିଁ। ଆଚ୍ଛା ତାପରେ ଭୁସି ଦେଇଛନ୍ତି। ପାଖରେ ପଡିଥିବା ଏକ ପଥରକୁ ଉଠାଇ ମୋର ମୁଣ୍ଡରେ ମାରି ଦେଇଥିଲେ। ମୁଁ ପଳେଇ ଯିବାରୁ ଚେଷ୍ଟା କରିବାରୁ ତାହା ମୋର ଗୋଡରେ ବାଜି ହାଡ଼ ଗୁଣ୍ଡ ହୋଇଯାଇଛି। ମୋର ଗଭୀର କ୍ଷତ ହୋଇ ପ୍ରବଳ ରକ୍ତସ୍ରାବ ହେବାରୁ ମୁଁ ତଳେ ପଡିଯାଇ ଅଚେତ ହୋଇଗଲି। ଉପସ୍ଥିତ ଥିବା ଲୋକମାନଙ୍କ ସାହାଯ୍ୟରେ ଅଚେତ ଅବସ୍ଥାରେ ମତେ ଡାକ୍ତରଖାନା ଚିକିତ୍ସା ପାଇଁ ନେଲେ। How everything is okay, but second application, yes, ma'am. Once it has been rejected on merit.
Well, this circumstantial injury simple thila that.
No, my lord. Grievous injury भी अच्छी. 3 injury report that lordship.
One point already released on bail by this court of session just today. Page 16. My lord.
Page 16.
Yes.
Kanna, alias Pradeep.
I see one of them. One of them. The petitioner apprehends arrest in connection with such and such case. The prosecution case is that the petitioner and petitioner and two other persons brutally assaulted the victim, the injured victim, who is their friend, while they were having a discussion. Most of the injuries appear to be are simple in nature and not on vital parts of the body.
Some grievous injury.
Yeah. Though there is a grievous injury, but it is not on the vital part. Though it is, though there is a grievous injury, same is not on the vital part of the body. Perusal of the statement of the injured does not reveal any specific overt act being attributed to the petitioner. Stop. Further, the co-accused, Kanha कौन था ना?
Pradeep Parida.
Kanha alias Parida who stands on the same footing, has been released on bail by the court below. Taking into consideration all the other facts, I am inclined to take a lenient view. However, I am not inclined to grant anticipatory bail to the petitioner. While not being inclined to grant anticipatory bail, he is directed to surrender, and in such event he shall be released on bail. Each day appearance without seeking representation. Yes.
Item 39.
May I please, Your Lordship? Second General Lordship. The alleged offence is 307.
326 ଅଛି.
323, 294, 506, 326, 307, Your Lordship. Earlier से not press ହେଇଥିଲା.
Not press ହେଇଥିଲା କାହିଁ କହିଲେ? It appears from the statement of the injured himself that the allegation of assault is mainly against petitioner number 1.
Yes, Your Lordship. That
Those specific allegation and
Lordship say the son of the informant assaulted and outraged modesty of the wife of the petitioner, for which says file in 1cc case. 1cc case number 1 of 2024. That is
Injury
next
kota
as
thila?
annexure
Yes,
1.
my
Your
lord.
Lordship.
कौन injuries?
Three injury, my lord, all are grievous. And one thumb has been amputated, my lord. And he has admitted in hospital on 16 December and discharged on 12 December.
First or second or?
Carried.
Clarity करो. Court तक देखिए. The petitioner is apprehending arrest in such and such case. It is alleged that the petitioner ଆଉ ଜଣେ କିଏ? Yeah.
ଏଠି ଜଣେ petitioner.
ନାଇଁ ଆଉ ଜଣେ କିଏ ତାଙ୍କ ସାଙ୍ଗରେ ଥିଲେ?
ନବକିଶୋର.
ଦି ଜଣ ମିଶିକି ମାରିଲେ ତ?
Nabhageshwar Mahabal. No, specific A marle.
ଦି ଜଣ ଥିଲେ ତ allegation? Yes, it is alleged that I will not mention that. That will prejudice her. Why should I? It is alleged that the petitioner and another person assaulted the informant.
Yes,
Son of him.
Son of the informant, causing injuries. Stop. It is submitted that the co-accused has been released on bail. Stop. Considering the nature of accusations and the materials on record, while not being inclined to grant anticipatory bail to the petitioner, first or second or.
Carried.
এই କେସରେ ମୁଁ ନିଜେ ଅର୍ଡର ନେଇଛି, ମୁଁ କେମିତି କ୍ଲାରିଟି କରିବି ବୋଲି ମୁଁ ଲିଖିଲି ଯେ it appears from the statement of the injured himself that the allegation of assault is mainly against petitioner number 1. There is no allegation against petitioner number 2 regarding the alleged assault. That is why he was granted bail. Now I will say that maintain parity. ते बंद कर लीजिए. ये जहाँ तक अपन move
Application Miller no way related because that is the Miller in a GR case. And that ended with the Miller final form. There
protest petition file, cognizance taken, 3 SC and 50.
So hello, protest petition, hello, it's a case na.
Yes,
So,
my lord.
all right.
Cognizance has been taken.
प्रमोद राय सरीगला गोटे दिटा देखिए ऑर्डर्स देखिए ଆଉ ତ ଟାଇମ ହେଇଗଲାଣି ଆଉ କଣ କରିବା ଆରେ ସପ୍ଲିମେଣ୍ଟାରୀ ସରିଗଲା ତ ୱିକଲିରେ ଯୋଉଠି ଛାଡିଥିଲେ ଅର୍ଡର୍ସ ରେ ସେଇଟା ନା
list item number 13.
Limitation has occurred.
Yes.
In filing the appeal, along with a application for permission to file the appeal. Your state was not included as a party. You know, a trial court had found specifically that the land belongs to state having not been included as a party.
Other side has appeared, Mr. Samir Kumar Mishra.
Yes.
You serve copy?
No, he wanted to take the copy and I will serve it in course of today.
Let copy
By tomorrow I will serve.
Let copies of the no, either thou tell pass over thou.
Ah, yeah.
Huh? You serve copy so that we can take it up tomorrow. Whatever order will be passed tomorrow. Yes.
Item number 14.
Refused.
Addresses have not been made sufficient.
No, one on one it has been refused.
Yes, ma'am. Regarding two, my lord, R12.
R12 कसा लिखा है नहीं?
No, my lord, there is no notice.
Such notice issued on R13 return unserved with the postal report address out of station. You have to take fresh notice.
Yes, my lord. My lord,
On R4 and R7, R8 rather, insufficient address. Fresh requisites with sufficient address.
Rest of my lord, all
1V to 1A returned unserved with the postal, no such address he found. No such address. Author notice not. Sabu.
Yes, my lord.
Excepting this respondent number 1I.
1I.
Hello?
Yes.
Office note indicates that notice issued on respondent number 1, bracket a small I, was refused. The same is therefore held to be sufficient. Insofar as the other respondents are concerned, let fresh notice be taken against them by registered post with AD, fixing a returnable within 4 weeks. Requisites
2 weeks, my lord.
Okay?
2 weeks, my lord. I have to take
requisites indicating the correct address of the respondents be filed within how much time?
2 weeks, my lord.
2 weeks will be long.
My lord, correct addresses I have to collect.
Within 2 weeks. Since it is submitted that the present addresses of the respondents need to be obtained. List this matter.
Then we will commence in 12th August.
It will be commencing 12th August.
Item 15.
15, my lord, praying for an adjournment, my lord. Comply lordship's order. Whereabouts of the parties is willing, sir.
Delete code at your risk.
Delete. Lordship,
Why did you not file requisites?
by whereabouts of the opposite party number 5, respondent 5.
Yes. When was
It is
the
very
direction?
difficult to get. He happens to be the vendor of the plaintiff.
No. And respondent number 2, 3 and 4 has returned undelivered with postal endorsement deceased. So you'll have to take steps for substitution.
Time may be, further time may be.
Land Council wants some time to file a petition for substitution in respect of respondent number. Notice on respondent number 5 has returned undelivered with postal endorsement long absent. First notice be issued by registered post. कौन इसी से appear कर ले? Respondent number 5 has appeared.
No one has.
Requisite is not filed. देखो.
Time may be granted.
No time. What is this? I passed this order in April. Today we are in July.
No, my lord, the whereabouts of the parties is very difficult to get.
You have to take fresh notice on respondent number 5.
Lordship may grant me time. Further 1 week time, I will take necessary steps.
1 week time is allowed to the appellant to take steps for substitution and also to file requisites for. Is it yes, requisites for issuance of notice on respondent number 5 as directed earlier. List this matter.
22nd July.
22nd July.
Item 16.
If requisites, if this order is not complied with within 7 days, the appeal shall stand dismissed without any further reference to the bench. Yes.
Item 16. Item 16, my lord, there's two appeal. The first.
Two appeals.
There are two appeals.
Yes.
For noting is concerned, one expired. I have to take.
Appeal notice issued on respondent one, the registered post to the returned address. Address is deceased. So you have to take.
I have to take notice for the substitution.
Steps for substitution on respondent number one. Steps for substitution, vice respondent number one be taken within 2 weeks. Fresh notice be issued to respondent number 6, furnishing the correct address. Huh. Such notice shall be issued by registered post.
He is residing there, but noting are moved. Somewhere or other he may be moved there. And
Such notice be issued by registered post, fixing registered post, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter after service of notice.
Item 17.
Yes, sir. ये जो connected matter है कौन है वो?
सब item रे भी कितना मरिए चंद one.
लिखाएंगे.
In both the cases, I am appearing for some of the respondents. The appellant has to take steps for substitution also.
Who are the deceased? No, हाँ, this is expired है.
One E.
Steps for substitution be taken. This is a connected matter लिखी है ना? As a fresh notice be taken against for issuance of notice on respondent number 4 and 5. 4, 5 and 6. Address he moved a 3 page. By the registered post to the
Parties are same, man. Parties are same in both the items.
But notice has to.
Yes.
Item 17.
Your Lordship, item 17, the notice served on respondent number 1 has returned with a postal report that the address has expired. I pray for some time to take instructions regarding the substitution of LRs of the respondent number 1.
Steps for substitution. Vice respondent number 1 be taken within a week.
2 weeks, Your Lordship.
Within a week. Yes, list this matter.
2nd July.
Yes.
Item 18.
Obliged.
Item 18. Kali, pass over.
Item 19.
I'm for the respondent.
Pass over. Contingent service, na?
Current to mention, my lord. Admission matters are there.
Yes.
Tomorrow, admission. Current to mention.
Tomorrow is 4th, ne? No, orders matter is over, excepting 2 passover matters. We will begin with admission now.
Current to mention, my lord, item 29 listed to some other date, my lord. I have taken consent from the advocate for the appellant, my lord.
Item 29.
Yes, my lord.
All right.
After 15 any date, my lord.
Is this matter in the week commencing 29th July? Yes.
Yes.